Thank you, sir. Good morning, y'all. Does anybody need to report anything with the admonition? Okay, great. Thank you all. Is Carmel ready to call our next witness? Thank you. Good morning.
Good morning.
Do you swear to tell the truth and the whole truth?
Yes, ma'am.
Thank you. You can have a seat.
Could you tell the jury your name?
Chadwick Allgaier.
Currently, where do you work?
I'm a probation officer with the Division of Probation and Parole.
Back in 2016, where did you work?
I worked for the Louisville Metro Police Department as a crime scene technician.
How long were you a crime scene technician?
6 years.
When did you leave?
I left in August of 2016.
So back in May, did you do some work on the case that we're here to talk about?
Yes, I did.
Sorry about that, sir. Now, the first thing that you did, what was your initial involvement in the case?
I believe initially I may have assisted on a search warrant at a house. And then the other involvement after that was processing a vehicle.
Okay, so the search warrant on the house, was that on Haight Avenue?
I believe so,
And
yes.
did you collect 2 knives?
Without reference to my report, I couldn't recall.
Okay, if I showed you the report, would you remember?
Yes.
One second, sorry. I'm going to the number so I can find this more quickly. Maybe it's about 52. Okay, sorry.
May.
You can just look that over.
Sure. Okay.
Okay, so if you recall now, did you collect 2 knives on River Park?
On Hyde Avenue.
On
Yes.
Hyde Avenue, sorry. Then on May 25th, did you do something else on this case?
Yes, I was called to go to the auto theft garage and process a vehicle.
Okay, what does process a vehicle mean?
Initially, we take photographs of the vehicle to start with, and then we do kind of a visual search of the vehicle to see if there's anything that's in plain view that we're going to collect. And then after that, it's forensically done, whether it's what the detective wants collected.
And in this case, did you take photographs of the vehicle?
I did, yes.
Your Honor, may I approach the witness?
You may.
I'm showing you what we have marked as 137, 148. Do you recognize those photos?
Yes, these would have been the photos that I took of the vehicle.
Introduce 137 and 148.
Any objection?
No
So
objection.
admitted.
Okay, I'm gonna go through, is it up on your screen right
Yes,
now?
it is.
Okay, I'm gonna go through these photos. So what are we looking at here in this one?
This appears to be a Mazda four-door sedan vehicle.
And is this the car you processed that day?
It is, yes.
Which I believe was May 25th, 2016, correct?
Yes,
Is that the rear of the car?
that is the rear of the vehicle, yes. That would be an interior view from the driver's side door, front driver's side.
Front or seats there?
Yes. Then that would be looking into the vehicle, the rear passenger seat from the driver's side. That's the interior of the trunk. That is the interior of the rear seat area from the passenger side on the back. And I believe I took this one on the rear passenger side door, looking into the rear seat and the trunk area.
So where those seat belts are, would that be the rear seats?
Yes, that's where they would be, yes.
And where that well is that the trunk?
Yes. I believe that's a photo of the registration that was found in the vehicle.
And can you might not be able to see it on the screen, but if you could look at the photograph, who's the name on the registration?
It says the owner's name is a Lashana Rhodes.
And what's this?
So this is a picture. I'm not sure what area it is because it's so dark. But this would be a photograph of the chemiluminescence from the Blue Star forensics that was applied to the vehicle.
How does that work? Tell the jury,
So
please.
basically, Blue Star forensics is a chemical product that will react with certain components that are contained in blood.
So how do you get it onto the car?
So it comes in a tablet form. We take those tablets, put them in with water in a spray bottle, kind of stir it around, let them dissolve. And once it's dissolved, the area needs to be dark for the chemiluminescence to be visible. But once it's applied, we apply it via spray bottle and just spray it on the areas that we want to, that we're interested in. And then we take pictures on a time lapse to see if there's any reaction.
So where do we see it, if at all, on this video?
Let me pull up, because it's hard to see on the video. I believe, looking at this, it may be the trunk area.
But I just meant, like, because I know this is kind of a dumb question, but just to go through it all procedurally, where on this picture is the Blue Star showing up?
It's all the blue areas that are marked is what the reaction was from the Blue Star.
I know, like, it's kind of obvious, but we got to go through the questions. Thank you very much. And then here, what do we have here?
This is again, looks like the trunk area from the rear. And again, all the blue areas would have been reactions from the Blue Star. This again, I believe this is from the interior, the rear passenger side. And again, the blue areas that are luminescent would be the reaction from the Blue Star.
And where are you doing this analysis?
This is in our auto theft garage, was a secured facility.
Is it an interior where you're able to turn off all the lights?
It is, yes. Again, just another picture. And again, all the blue areas there would be reactions from the Blue Star.
After you did the Blue Star and took the photographs, what did you do?
I believe we processed the car, and by processing, I believe I was asked to do latent fingerprints on the vehicle. And I don't believe, if I recall from the report, that we got any fingerprints that were viable off of it. And then from there, I believe we did a lot of swabbing. Swabbing would be for the purposes of trying to obtain DNA to place people in the vehicle. I believe we did trace lifts off the seats, and possibly some of the trunk or floorboard areas. Without the actual report, I can't say specifically what we did, but I know that we did swabs, fingerprints, and trace lifts.
And if you had your actual report to look at, would it help refresh your
It
memory?
would, yes. Okay, so yeah, so again, I processed the vehicle for latent fingerprints. We got negative results, which means there wasn't anything viable that could be used to search against. And then I collected swabs of the interior front driver's side door handle, the steering wheel, the gear shift knob, the front driver's seat recline lever, the rear driver's side interior door handle, the rear passenger side interior door handle, the front passenger side interior door handle, and then swabs from the front passenger seat recline lever. And then as far as the trace lifts we did, took those from the front driver's seat headrest, the front driver's seat back, which is what you would lean your back against, the front driver's seat area, the front passenger seat headrest, the front passenger seat back, and then the front passenger seat itself.
What are trace lifts?
So trace lifts is basically, if you just think about like a large piece of clear tape, if you will. And basically what we do is it comes on a sealed protector. We peel that off and back, and then we apply the lift on whatever object it is we want to get that trace lift from. And then we smooth it out to get good adherence on it. And then we lift that up, put it back over the protective covering. And what that does is it will gather and protect any kind of fibers, hairs, anything like that that would be on contact with another object.
And what is the goal on a trace lift?
So on trace lift, you're looking for fibers, hairs, anything that can be used to identify an object or a person.
Would your plan be for it to be sent to a lab?
Yes.
And then for the swabs, what are swabs?
So swabs we use to collect those, what we call touch DNA. So anytime a person touches an object, you're going to leave behind a trace of something, whether it's sweat, epithelial cells, which is basically your skin, potential for blood. So the goal of the swab is to swab an object, send that off to the lab to hopefully obtain DNA that can be matched with someone to identify or place a person that touched an object or in a place.
And for the prints, if there are fingerprints, if there are no fingerprints found in a car, does that mean that no one's ever touched the car?
No, it does not.
What could happen to disturb fingerprints?
So fingerprints are very sensitive. You know, obviously objects are touched. Anytime you touch an object, you're going to leave a fingerprint behind. But with common objects like a vehicle, door handles, gear shift knobs, steering wheels, all those fingerprints are just constantly, they're rubbed off, they're placed over one another. It's very hard to get a viable fingerprint off of a commonly touched object.
I'm gonna get my.
Sure.
And I have no further questions.
Morning, Detective, or Mr. Allgaier, how are you?
Morning, I'm good. How are you?
Good, thank you. Former Detective Middleton testified in this case, and I know you weren't here, but I believe he told the jury that during the search of Hyde Avenue, he located 2 knives and a hammer. But you didn't collect the hammer, correct?
According to my report, I only collected the 2 knives that I recall.
And there were 2 searches of Hyde Avenue. Were you present for both of those?
No, I was not.
The first one,
Yes.
to your knowledge? Did you take any video during that search?
I don't believe so, but again, without the report, I couldn't say yes or no 100%.
You also said you assisted in the processing of the blue Mazda, correct?
Yes.
On the report, were you with Officer Kim during the processing of that vehicle?
Without referencing the report, I don't recall off the top of my head who all was present there for that.
Well, in the report, it says that the vehicle was a gray Nissan Altima 4-door. Did that? Yeah. Mr. Algar, did you test a gray Nissan Altima to your knowledge with regard to this case?
Not to my knowledge, no.
In the pictures, the vehicle did not appear to have a back seat in it. Is that correct?
Correct.
At any time, did it have a back seat when you worked on the vehicle?
No, it did not.
Did anyone ever, from Louisville Metro Police Department, ever bring you a back seat of that vehicle to test at any point later?
Not to me directly, no.
I think you testified that you did a lot of swabbing.
Yes.
And you testified that you swabbed the car seats, I believe, but you didn't swab the floor where the back seat had supposedly been removed or in the trunk, correct?
Again, without referencing my report, I couldn't tell you.
If I showed you the report, would that help?
Yes.
May I approach the witness?
You may.
Thank you. And what was your question again? I'm
My
sorry.
question was whether you had swabbed the floorboard where the back seat would have been or in the trunk.
Okay. We did take some swabs from the rear passenger side floorboard. Yes.
What about underneath where the seat would have been?
According to the report, we did not.
Thank you.
Sure.
That's all the questions I have for you.
Any regret?
No.
All right, you're free to go. Thank you.
Thank you.
The Commonwealth's next witness, please.
Your Honor, the Commonwealth will call Brice Rhodes,
Thank you.
detective.
Good morning.
Morning.
May I have you raise your right hand, please? Do you swear to tell the truth and the whole truth?
I do.
Thank you. You may have a seat.
Good morning.
Morning.
Can you introduce yourself to the jury?
My name is Brian Royce.
And how are you employed?
Currently, I'm with local Metro Police Department.
And what is your position with LMPD?
I'm currently a civilian investigator in the cold case homicide unit.
And how were you employed back in 2016?
I was also employed by local Metro Police Department. I was in a detective capacity in the homicide unit.
And in connection with this case, did you perform a processing of a vehicle associated with this case?
I did.
Okay. And the jury's just heard a little bit about processing. So what vehicle was it you were looking into?
This was a 2016 Dodge Charger. Yes. Yes, the plate matches.
The
Yes.
Charger.
Yes.
I just showed him what's been previously marked Commonwealth's 149.
Any objection?
No objection.
You may admit and publish, or it is admitted and you may publish.
So where did you encounter the vehicle?
This was already at the auto theft garage.
Okay. And that's what happens at the auto theft garage? Why was the vehicle there?
That would be stored there until it can be processed or released.
And who made the determination that you should process this vehicle?
That would be at the direction of lead detective.
And so how did you process this vehicle?
Detective Snyder obtained a consent search for the vehicle that allowed us to actually search the vehicle and document its contents and record anything that we thought may be of evidentiary value.
And did you find anything in the vehicle of evidentiary
We
value?
took, or I say we, the CSU technician, Megan Brown, was present with me. She documented the vehicle with photographs. We did some print lifts and some trace lifts. And I believe there were a couple articles of clothing recovered from the trunk of the vehicle.
And did any of those examinations return anything interesting?
I do not know.
Okay. What do you do were you there when the lifts were taken?
I was.
Okay. And then from the time that they're taken, where do they go from there?
The crime scene unit technicians handle that evidence.
And did you take the photograph
Did I take
of
photographs?
the Charger?
The CSU technician did.
And were you there when trace lifts were taken?
I was.
And where did the trace lifts go from there?
Again, that type of evidence goes with CSU to the lab.
No further questions, Your Honor.
Any questions for this witness?
You just testified to the processing with the 2016 Dodge Charger that you were present for, correct?
Correct.
You were also involved in another piece of this case, correct?
You'll have to refresh my memory.
You were involved in a search of Height Street Avenue.
I recall being present for one of the executions of one of the warrants.
At Height Street,
That's correct.
and you were present there when there was Blue Star applied,
I was.
and you were present when there was a scene video taken of that Blue Star processing attempt.
I can't say that I was still present at that time.
And did you obtain a scene video of that Blue Star processing attempt?
Did I?
Did you yourself?
No.
And you've never seen or viewed such a video?
I have not.
No more questions, Your Honor.
Any redirect?
No.
All right, you're free to go, Detective. Thank you.
Thank you.
Ms. Jones Brown, your next witness.
I come up with Brian Peters.
Thank you. Good morning. Have you raised your right hand, please? Do you swear to tell the truth and the whole truth?
I do.
Thank you. You may have a seat.
Please introduce yourself to the jury.
I'm Detective Brian Peters with Louisville Metro Police.
How long have you been with LMPD?
I served just over 20 years, retired a little over a year and a half ago, and then I've been back with LMPD as a rehire, as a detective again, for a little, about a year and a half now, or close to a year and a half.
And where are you currently stationed?
Currently, I'm serving our public integrity unit.
Back in 2016, where were you?
I was assigned in our the Metro's homicide unit. At that time, I was specifically assigned to the cold case unit.
And how long were you with homicide in total?
Approximately 13 years total.
What was your involvement in the case of Brice Rhodes?
My involvement, I did not make the initial scene where the victims were located. My involvement was following up on an investigative lead that led us to a location over on Hackle Drive regarding a dumpster fire where ultimately we retrieved items.
So before you went to Hackle, where were you? Where were you when you got notified that you were going to be involved in this case?
Okay. Kind of the way a lot of homicides work. There's a lot of moving parts. Myself, my partner at the time, again, we were assigned a cold case unit. We were actually asked to assist in this investigation by responding where a search warrant was being executed, I believe at the defendant's home. On our arrival, we were asked to search for a specific vehicle, which we later located in the same parking lot.
What kind of vehicle was that?
It was like a light blue Mazda 4-door car.
And after you located the vehicle, what'd you do?
We located the vehicle. The back windows were down, I believe. There was a strong smell of bleach, chemical-like substance emanating from the car. The back seat, as we approached closer, it was missing from the vehicle. At that point, myself and my partner, we began searching the apartment complex for dumpsters, obviously looking for the seat that was in the vehicle. We even searched nearby neighborhoods, areas where there might be dumpsters or anything. It had been discarded in that manner.
Did you find anything?
We didn't. At that point, since we had not located it, obviously we believed it to be of significant value. I made a request and through our Metro Safe dispatch for any dumpster fires that may have been within about, I believe, like the last 48 hours or so. I kind of went from the time frame of when we believe so it was 2 days later, I believe, that we were at that apartment complex from when the initial homicides occurred. So we kind of did a wide time range as far as trying to locate any dumpster fires.
How would Metro Safe know about dumpster fires?
Typically, they're called in. If somebody calls in, as it was just like a car accident or whatever, they would call in, and then the fire, whoever would respond.
Do you mean call 911?
Yes.
So how many 911 calls have been made about dumpster fires?
There were several. I want to say it might have been somewhere around 7 or 8.
And did you follow up on each of them?
We did, yes.
What did you, was Hackle Drive the last one you went to?
It happened to be, yes.
Okay, so on the
last one.
previous dumpsters, what did you find at each of them?
Nothing of significant value. I believe one of them was actually a repeated phone call, a duplicate call. I think even one of them may have had just like very small, minimal damage. I think we spoke to an employee at like one of the Dollar Generals. He said it was kids just like trying to attempt to light it on fire. But we never found anything of significance until we got to Hackle Drive.
Had some of them already been emptied?
They had, yes.
So you get to Hackle and was it your understanding that somebody had called in a dumpster fire?
That's correct, yes.
What did you find when you got there?
When we first got there, there was it was the last one that we checked. We kind of began like about midday checking these. It was already dark by the time we arrived. There was an older gentleman outside in the rear of one of the buildings in the 6500 block. I asked him if he was the one who initially made the 911 call on the dumpster fire. He said no. He did direct me to a building where he believed, I guess the caller lived at. The dumpster itself had significant damage to it. I mean, it was the most significant damaged one we came across in our search.
Okay. And you have been using the pronoun we. Who were you with?
My partner at the time, Detective Matt Metzler, who also worked in homicide with me.
So what did you all do with this dumpster?
We approached it. Obviously, it was a substantial fire. It appeared to be because a lot of the paint was melted off. There was a significant amount of water in there. That dumpster appeared to be about halfway full, if I recall. We obviously, again, it was dark. There appeared to be what just kind of really almost at the, I guess, at the top of the water level, what we believed to be at that time remnants of like a seat cushion in the dumpster. So at that point, we secured that scene like we would any crime scene. We've roped it off with crime scene tape, and obviously made a request for our crime scene unit to come out to assist.
What was this still on May 24th?
This would have been, I believe it was May 24th. And again, I want to say it might have been about 2 days after the homicides.
And how were you there? How long were you there?
Several hours.
Did it go into the 25th?
It did, yes.
So did crime scene technician Kimmer arrive?
That's correct.
Okay. And was she with? Were there two crime scene technicians?
I believe so. Again, when we initially got on that scene, there was a search warrant being executed, and I believe we were waiting for them to conclude, I guess, their collection of any items there before they came to our scene.
And you mean a different search warrant, right?
Yes, that's correct.
So when CSU got there, what happened?
We started. We actually were in Tyvek suits. And obviously it entered the dumpster and tried to, I guess, again, had a substantial amount of water in it. We started pulling items out individually and trying to ascertain what would be possibly involved in our investigation.
I'm gonna show some photos that have been previously introduced by technician Kimmer. Is that the dumpster?
It appears to be, yes.
Okay. So, is this what you were faced with when you first got there?
It was, yes.
How did you know what to collect?
So obviously our initial, I guess, approach to this, we were looking for the backseat of a vehicle. Once we actually get to this dumpster and kind of start going through items, we start discovering things that we believe are possibly involved. There were several items, I think you kind of skipped through a few as well, that appear to have, and I don't know how it.
I'll just start at the first one and you tell me, let me know if you want to talk about something.
Okay. I know the picture's a little grainy on there compared to what I'm looking at on this screen. This one has, like, you have some burn marks through here. These little spots here, they appear to be blood. Like right there, here, kind of on the ends. These appear to be like the burn marks. And then again, you have a little bit more possible blood here and up there. Can't tell if that's kind of a bit better to see here, but this appears to be blood here. These appear to be burn marks through here. Again, you have what appears to be saturated blood as well. And again, over here. Again, this would have been the towel from the previous picture, or what appears to be a towel. Again, you have what appears to be the suspected blood here on the edges over here, kind of throughout the towel. And then these are all just burn marks here.
I'm gonna
This, or I'm sorry.
There we go.
Okay. Right here, this is going to be what appears to, I think this is like this is going to be like a sheet here, but this is really saturated with blood. I know the coloring looks bad here, but this is real dark red through here. These again appear to be some burn marks on here as well. And
I think that's just a close-up of the same picture.
And that's just going to be when we remove that item after, and we photograph everything as it is before we actually retrieve it. And obviously we want to look at it a little bit closer and to follow up before we collect it. But again, this is going to be that item. I think you can see much better here that kind of the red coloration here, what appears to be blood. And then these are all going to be just little remnants of the burn marks here. So in this one, I think this is going to be here. I think this is like almost like a comforter here. Obviously significant burn where it had obviously sustained fire damage. That's going to be the item once it's removed from the dumpster, and you have significant burn marks here as well. This one, obviously the coloration of it, it's kind of hard to tell. It looks to appear to be blood through here, and again over here.
Is in the upper left corner, is that a shoe, just for perspective on the
Oh, I'm
size
sorry.
of
Are you
this?
talking right here?
Yeah.
Yes, it is. This appears to be like a sofa cushion. It was recovered and it was photographed, pulled out. It has significant burn damage as well throughout there. This is going to be another towel, like I guess like a washcloth. It appears to be actually like I don't know what, see right here, I don't know if that's kind of part of where it's ripped off. But this is just another towel that we recovered that also has some burn damage to it. So this appears to be another cushion, a pillow right through here that we recovered. It appears to have like saturated blood here. It's like a good amount through this area. This is your burn marks on it over here. And again, this is going to be the cushion laid out once we recover it from the dumpster. You can see the significant burn there. This one looks to be a pillowcase right here. This is real, what we suspect to be blood as well, kind of up here. It does have a little bit of a burn mark through here, but this is going to be your suspected blood through there. And that's just, let's see. This is going to be, okay, we did pull these two items out, not knowing if they were some type of flame accelerant. They were not. Actually, we called for arson to come out. We learned when they came out, it was actually just 2 jugs of urine.
And are we getting into like the bottom part of the dumpster at this
We
point?
are, that's correct.
Just a close-up of the same scene.
Mhm. Okay, I believe this item here, we pulled out as well, and along with this one. This one appears to be more bedding. Again, you have what appears to be suspected blood all over this one, heavily here and up here. There are several burn marks on here, especially right in this area. See this one here, this item here, do we have another picture? I think that might be part of that. But it has some, let's see.
I think that's it.
Okay. This one might have been the bottom part of I guess, another part of that bedding that was right there, but it had significant burn damage as well. And so did this remnants of what appeared to be a carpet on this one as well. Okay, this is my partner, Detective Metzler. As we recover bedding out of there, out of the dumpster, this one has a lot of significant stains, all appear to be blood, as well as identifying markers on here that show that it was there when the fire was initiated. And that's going to be the item that Detective Metzler retrieved. This here, he's appears to be significant spot of blood here, as well as identifying marks right through here and up here. I'm sorry,
This is a close to the same one.
it appears to be, yes. And that's, I believe, still going to be the same art item. Let's see. And these are going to be, I'm sorry, is obviously we'll take photos of things in the dumpster, we recover it, place it out, we'll photograph things. A picture like this is going to be actually in our crime scene lab, where once we have an opportunity to kind of even detail it a little bit more. So this is going to be one of the items that we recovered.
When you realized that you had found the dumpster that probably had evidentiary significance, how did you notify anybody about this?
Okay. Again, we were looking for backseat of a vehicle initially. Obviously, when we get over to the dumpster, as we kind of approach, I observed what I thought were remnants, like stuffing from the inside of a seat cushion. It would appear to be maybe even like little springs. I notified our homicide commander, Lieutenant Kessinger, at that time.
And what did you tell him?
I told him, obviously, he was aware the back seat was missing from the vehicle. I told him that I believe that we may have remnants of one, that there had been a significant dumpster fire, and that we were going to try to attempt to retrieve any items that from that dumpster pertaining to the case.
How long did you have to wait for CSU?
Offhand, I don't know. It may have been an hour, it may have been two. We roped it off. Obviously, we secured it from that point. Nobody had any access to the dumpster at that point.
And when CSU came, how long did that whole process of taking each item, photographing, taking each item out, photographing again, how long did that take?
So it's very time consuming, especially in the pictures you were looking at with a dumpster like that. You don't want to just go through it too quick. You want to kind of process each item as best as you can. Obviously, the fire damage played a role in that as well. So it took several hours.
Do you recall when you cleared the scene?
It was the following day. It was sometime that morning. I mean, when we got there, it was dark. I would say late in the evening, maybe around 10:30. We may have been there 12 hours, maybe somewhere around there.
And did you later return to do follow-up interviews of residents?
We did. The ones that the gentleman had told us he believed to be the ones that called 911. We did.
Thank you. I have no further questions.
Okay.
Detective Peters, you were referencing you said you searched several dumpsters, correct?
That's correct.
And the one you were referencing was the one located on Hackle Drive, correct?
That's correct.
And that fire, according to your report, was reported on May the 22nd. Is that correct?
I believe so, yes.
But you didn't search that dumpster until 2 days later.
That's correct. We weren't looking for, I believe it was 2 days later when we actually found the vehicle that was missing the back seat. And at that point, that's when we tried to make efforts into locating it.
One of your colleagues testified that they had taken a picture of the Mazda as found. And the picture did not have the windows rolled down. And your testimony here today was that the 2 back windows were rolled down.
I believe so.
Did you take that picture?
I don't recall I don't believe I took that picture. And I don't recall who took the photo. Again, I do recall when we approached the vehicle, it had a strong odor of bleach emanating from the car.
And back to the scene at Hackle Drive of the suspected dumpster fire. You arrived on the scene, you said, before the crime scene unit did.
That's correct.
And so those pictures that you were showing the jury were taken after you had arrived on the scene.
Are you referring to the dumpster? Or
Yes,
is
the
that correct?
pictures
Yes.
that were shown to the jury today.
I believe so, yes.
Thank you. No further questions.
Redirect.
Judge, can we approach?
Sure. Some pictures on my computer. Particularly this one.
Do you recognize those photographs?
I have seen them before, yes.
And are those a fair and accurate representation of how the Mazda looked on May 22nd?
It is, yes.
Your Honor, the call on this to introduce these two photos and publish to the jury. They will be exhibits.
150 and 151.
Admitted subject to prior conversation. You all want to approach? So you look like you're questioning, and I don't want to, if you
Yes,
want to
let's
put
do.
something on
Just-
the
I
record,
have
let's
a
do it.
question.
Yeah, no problem.
And to clarify, are you the one, or were you part of the team that first located the Mazda?
That's correct, yes.
And did anybody enter the Mazda and roll windows up or down?
I don't recall, no.
Is that something the police department would ever do?
No, typically, again, you want to obviously contain any evidence as we locate it. And we don't want to obviously tamper with it anyway. Obviously, the most minimal contamination as possible.
And once you all located the Mazda, was it secured?
It would have been yes.
So no civilians could have come and gone from the Mazda?
No, absolutely not.
So. All right, and what are we looking at here?
Okay, this vehicle here is going to be the light blue Mazda. It may look a little silver in this picture, but it's like a light blue.
Is this where you all located?
I believe so, yes.
Do you recall it was parked in a normal parking space?
That is correct.
And from this distance, would you have smelled bleach?
Yes.
And does the window appear to be up or down?
The back window appears to be up, front driver window appears to be down.
And what are we looking at? in this picture?
This is going to be a photo, I guess, on the driver's side door into the vehicle. Again, the window appears to be down.
And at this point, was the back seat?
It was, yes.
Your Honor, I have no further questions.
Any requests?
Detective Peters, just to clarify, you did tell the jury that the two back windows were down.
I said, I believe the back ones had been out, yes.
All right, you may step down. Thank you.
Thank you. Appreciate it.
And come up with your next witness, please.
Yes, Your Honor.
You know what? Actually, I think this is a good time for a little 5-minute break because somebody needs to step out. We will just come back in 5 minutes. It's 10 after 11.
Okay, a 5-minute break. I had read an article which I thought would be interesting to read. Let's see if I can find it again here.
I have this chance.
Take a look on my phone. Oh yeah, I remember what it was now. Sure, now that I want the article, where is it? Oh, here we go. Let's see. If I look a little further. So that I can show the picture. Here we go. Okay, here is the story. It says, kitten found in sandwich container is improving. And this is in Cottonwood Heights here in Salt Lake County. And it says a 6-week-old kitten found taped inside a sandwich container this week is making remarkable progress according to the clinic treating her. Monday around 2 a.m., Cottonwood Heights police spotted 2 people believed to be illegally camping and slumped over in their car, a police booking affidavit states. While questioning these 2 occupants, officers noticed they were covered with cat fur. The officers then heard a faint meow coming from the back seat of the car. A kitten was found in the back, stuffed into a sandwich-sized plastic container, which was duct taped shut with its head poking out. The officers gave the kitten water and took it to the police department until for further care until it could be taken to a veterinary clinic for examination. Angel Paws Veterinary Service took the kitten in. Despite initially being in very poor condition, the medical staff now believes that Athena, a 6-week Siamese, will make a mostly full recovery. According to the clinic, Athena was treated for head trauma, singed fur, bruising to her temple, and an eye injury. She also tested positive for meth and amphetamines, according to preliminary results. The kitten, weighing only 1.24 pounds, was named Athena by the clinic staff. She has been weaned off oxygen and is still receiving fluid support and medication to manage pain. The clinic said in a prepared statement on Tuesday. Clinic medical director Jessica Love, who has been providing treatment to Athena, said she wasn't sure at first if the kitten would make it. On Wednesday, she said she felt confident Athena would survive and make a good, healthy quality of life despite a long recovery ahead of her. The biggest concern, she said, was both of Athena's eyes. The long-term prognosis on how well Athena's eyes will function won't be known for a while, Love said. Whether Athena will be available for adoption at any time in the future was not immediately known. She is currently staying with a staff member of the clinic. A message on Angel Paw's Facebook page, however, states, if you or someone you know would like to donate to Athena's care, we would greatly appreciate your support. Angel Paws only treats homeless animals or those who come from shelter or rescue operations. The post also reminds owners to spay and neuter their animals and not offer their offspring for no charge. Not okay. Let's see. Justin Dale Epperson, 45, and Emily Maureen Allred, 45, were booked into Salt Lake County Jail for investigation of torture of a companion animal and drug possession. Formal charges had not been filed as of midday Wednesday. Police noted in their affidavit that methamphetamines and fentanyl were also found in the vehicle, and both Epperson and Allred have a history of drug-related crimes. They are repeat offenders, and this time they are showing no regard, and at this time they are showing no regard for the life by torturing a family pet, the affidavit states. So that struck me because I've there's my kitty Aowen. I've never thought about animals getting, being affected and so forth by illicit drug use. And yeah, it's kind of a scary thought. I mean, what happens if you've got a pit bull who's high on meth or fentanyl or something? I mean, that's kind of a scary proposition if you ask me. So, yeah, not good. So, let's see. We should be resuming coverage here anytime soon. Let's take a quick look on YouTube land and see what's out there. Oh, here we go. Now they turned the mic on. Nope. Not yet.
All for 15 jurors are present, Your Honor.
Thank you. Anybody need to report anything?
All right, who's the Commonwealth's next witness?
Commonwealth's going to call Dr. Lippy.
I'm sorry, could you say that again?
Dr. Lippincott,
Lippincott?
Lippincott.
Thank you. Good morning, doctor. May I have you raise your right hand, please? Sorry, could giving you a minute. Do you sort of tell the truth and the whole truth? I do. Thank you. You may have a seat.
Morning, doctor. How are you?
Good morning.
Can you introduce yourself to the jury?
I am Dr. Lauren Lippincott.
And can you tell us what sort of medicine do you practice?
I am a forensic pathologist.
And so what does a forensic pathologist do?
Forensic pathology is the field of medicine that examines unexpected, unexplained, and unnatural death.
And is there some training that goes along with becoming a doctor there?
Yes,
Can you tell us what's your education background?
sure. I have a bachelor's of science degree in forensic biology and health sciences from Guilford College. I received my medical degree at Nova Southeastern University. I then did a internship year at St. Petersburg General Hospital in Florida. I then did my residency in anatomic and clinical pathology at Danbury Hospital in Connecticut. And then I did my forensic pathology fellowship at the Office of the Chief Medical Examiner here in Louisville.
So how many years of education was that if you had them all
Sorry, let me do
That's-
the math. Approximately 15.
up? And how many autopsies have you performed at this point?
I have performed over 1,800 autopsies.
And what is the standard procedure for performing an autopsy? Do you pick who comes to you? How do they get there?
The autopsies that we performed are on decedents that are sent to us by the county coroner.
And this is the job that you were performing back in 2016.
Yes,
And this is, you had I was going to say opportunity, that's not quite the right word. You conducted the examination for a case number ME 160633.
yes.
And who was that individual?
That individual was identified as Christopher Jones.
And when you performed the autopsy, at that time, where does the autopsy occur?
The autopsy is performed at the medical examiner's office.
And who else are there other people in the room, just you?
There's technicians, there may be other doctors in the office, law enforcement.
Do you follow the same set of procedures for everybody that you receive, or do you tailor it based on what your initial observations are?
We have our general protocol, but some items are tailored for the nature of the case.
May I approach, Your Honor?
No.
Showing the witness, columns 152 through 150. Those pictures fairly and accurately represent Mr. Jones as you observed him to be at that time.
Yes,
Move to admit and publish, Your Honor.
No objection.
Admitted, you may publish.
May I approach the witness, Your Honor?
You may.
Then you control of the clicker on the corner there. Can you, I guess, first of all, I'll just kind of jump to your final conclusion to orient the jury. What did you find the cause of death in this instance to
The
be?
cause of death in this instance was a gunshot wound.
And can you point out where the gunshot wound is on the victim?
In this individual, the gunshot wound initially went through his arm and then entered into his torso.
And how did death result from that?
There was injury to the liver that resulted in bleeding.
How long would you expect somebody to survive with that sort of injury?
It's hard to say.
And so obviously the liver is an important organ. What happens when a liver gets punctured?
When there is injury to the liver, bleeding will occur into the abdomen.
And so you would expect most of that bleeding to be internal or external.
Depending on the nature of the wound.
Okay. Is there anything else significant about this particular photo?
In this photo, you do see a lot of evidence of the medical intervention that was performed prior.
And if you want to just go through the next photo,
Okay.
what is most significant about
Yeah.
this photo here?
In this photo, the significant item is right here. That was after we had made an incision under this contusion or bruise on his torso, and that is actually a projectile.
Now, are we looking at a bullet that almost exited? Or
No.
are we looking at an entrance?
That bullet was underneath the skin. We cut into the skin for visualization
Okay,
and retrieval.
okay. And there was only one bullet wound?
There
One.
was one projectile recovered.
Yes. All right. And we can go on to the next one. And what is this shot here?
This looks like it's the other side of his torso, so the lateral side where the projectile entered into the body.
And how can you tell, can you tell from just looking at the wound whether it's an entrance or an exit?
This one is a little irregular. So,
And irregular would mean what? I'm sorry.
because this is a re-entry wound because the bullet already had gone through a different area.
So I guess let's talk a little bit more about the processing also. I kind of jumped into things. There's a sticker there. Why is that sticker on it?
That sticker right here, it has our case number. Every individual that we examine in our facility is given their own case number. That number follows all of their case and anything involved with it. And then also on this, we also have measurements in inches and metric. So that also gives us a sense of scale.
Thank you. Go on to the next one. And there's, can you talk about his hands?
Yeah, you see that the hands were received at our office, covered in a paper bag.
And why is it like that?
That can be done to preserve any possible trace evidence.
When you say trace evidence, can you give some examples of what you sometimes find on people's hands?
I mean, sometimes it's also, we might clip fingernail clippings if requested for collection, and it may see if there's anything that could be important to law enforcement.
When you were processing Mr. Jones, did you encounter any injuries that would have been consistent with him having been run over by a vehicle?
I did not see any specific.
And there appears to be some darkness up on his head over his eye there. Did you observe that during your inspection?
Yes,
And do you know what the cause of that is?
no,
Is there any part of the infusion or treatment process that could cause results like that?
not that I'm aware.
Do you know do you know when that bruising would have occurred?
I'm not sure.
Can people bruise post-mortem?
No.
So do you keep careful records of your examination,
Yes,
and do you file a report?
we do.
And what's the rest of the procedure that you follow with an autopsy?
During the autopsy, say we examine the external surface of the individual. We look for injuries, natural disease. We will then generally also perform similar inspections inside the decedent's body. We will make incisions and look at the organs as they are in the body, and we will also remove them to look at them individually.
So why do you take, in a case like this where you can see a gunshot wound, why would you take out organs and weigh them still?
Just for documentation, to also see if there's other injuries, other natural disease.
Because you only get one shot at this and you don't know what might be relevant later.
Correct.
All right. Did you do anything else with respect to Mr. Jones?
Blood samples were collected from the hospital and were sent for toxicologic testing.
And what would that test for?
It generally tests for a panel that includes common drugs of abuse and alcohols.
Okay. And when did you perform the examination of Mr. Jones?
This exam was performed on May 4th, 2016.
And did you also happen to perform an examination in case ME 160724?
Yes,
And who was the individual involved in that examination?
that individual was identified as Larry Ordway.
At the time that you did your examination, did you have any knowledge that these two individuals were in any way connected?
No,
May I approach, Your Honor?
You may.
Showing the witness Commonwealth's Exhibit 160 through 176. Do those pictures fairly and accurately represent Mr. Ordway as you observed him at the time?
Generally, yes.
Move to admit and publish to the jury. Your Honor.
No objection.
So Bennett, you may.
We'll go through the pictures one by one, but first, again, I'll jump to what was your final conclusion as to the cause of death of Mr. Ordway?
The cause of death were due to multiple stab wounds of the torso.
Why would you take a picture? What's the significance of taking pictures of someone's hands? What's significant about that?
We take pictures of the hands to document any injuries or any other findings as they're received.
Did you see any wounds on his hands?
No,
Do you have?
sorry, I clicker.
Oh, yeah, sure. And that's his other hand,
Yeah, or another aspect of it.
and still no wounds,
No,
no defensive wounds.
no.
You can keep going. Did you observe burning on the body?
Yes,
And were you able to tell, was he deceased when the fire occurred? Is there any way for you to know that just from looking at him?
it's hard to tell with burning, but we did perform a carboxyhemoglobin testing for carbon monoxide, and that was negative.
Which would imply what generally?
Often if someone is, for the most part, deceased at the time of a fire, they will not be taking breaths to inhale it in.
And what are we looking at here?
We are looking at a stab wound.
Is there any way for you to tell what sort of instrument caused the wound?
No,
Would you be able to tell if the instrument was serrated or smooth?
we do document whether the wound edge is smooth or if we see evidence of serration.
And what was your conclusion on this one?
This was a smooth. Next.
Yeah. Can you orient us as to what we're looking at here?
So I believe we're looking at, on the torso, there is an injury here. And then you can see some of this darkening and discoloration is fire injury.
Same.
Same.
Plus, there's also, is that additional wounds in the?
Yeah,
photo?
there's multiple wounds in this photo.
Overall, do you count the number of wounds?
Yes.
How many wounds were there?
Overall, we documented 21 sharp force wounds.
And did all of the wounds hemorrhage?
Yes.
And what is that? What can you deduce from that knowledge?
When there is bleeding around from the wounds, it means that the heart was beating, person was alive.
So he would have felt all of these wounds. He would have been alive for all of these wounds.
Would have been presumably, yes.
I'm sorry, I'm alive or able to feel, which one? Because that was kind of put together.
It's if someone's alive,
Okay, but you would not or would know whether they were able to feel it.
it would depend on the level of consciousness in an individual.
So in this case, do you know?
I can't say.
Okay, okay. Thank you.
You can go on to the next one. Anything significant?
No,
Lower
still some
extremities?
of the some of the other fire burn injuries.
You can go on to the next one. What do you observe here?
Here is the side of his head. There's some burnt clothing and burnt skin underneath, some, looks like some singeing of the hair. And there was a contusion on the ear.
And what would people on the street call a contusion?
A contusion is a bruise.
And so do you have any way of knowing how long do bruises last?
They can last for, it depends, period of time.
Do you have any way of knowing how long that bruise existed?
No.
You can go on to the next one. And this is another shot of the bruising.
Yes.
You can. What are we looking at here? Can you
So here,
orient us?
yes, we're looking on the torso. There were some injuries here, and this is intestine protruding through the wound.
And if there's a incision to the midsection, is that something that naturally happens, or?
Yes, it can.
All right. What is significant in this photo?
And here there is some bruising on the forehead.
And this photo here?
And then here is, we're looking at his body from the top down. Head is here, going to the chest and abdomen. And here we can see multiple stab wounds.
Are all of the stab wounds on the front of the body?
The vast majority are.
You can go on to the next one. Can you tell anything about the depth of these wounds from looking at them during your examination?
On the external exam, we can give approximations of wound depth on internal exam.
And were these of consistent depth with each other?
They varied.
And do you know what the range was?
The depths of the wounds were ranged from 1/4 inch deep to 6 inches deep.
Go on to the next one. Do you know which body was the one that you would have examined in this photo?
I believe it is the one on the right because of the clothing.
And I don't know if there's another photo after this.
Yes.
Would a blade like this be consistent with the wounds that you saw?
I can't say.
Some knives you could rule out by looking at them. Is that fair to say?
Yes.
And is this one that you could rule out by looking at it?
I don't think it can be ruled out.
And if there's another one,
I think that's it.
that's it. And then you followed the same, after you did the documentation, you followed the same process as you laid out for Mr. Jones and documented your reports.
Yes.
I don't have any additional questions. Thank you.
For the defense?
Good morning.
I'm not gonna walk back through all the things you just testified about. I'm gonna pick and choose a little bit.
Okay,
And if any of my questions are confusing, just tell me.
okay.
I think it's probably clear, but I wanted to ask just a couple things about your office. Your office is, it's not just you, right? It's a bigger office.
Yes.
How many medical examiners are there?
I believe at the current moment in time, we have 8.
Okay.
in our office.
And in any particular autopsy, do you only have one, or do you guys work, do you work in pairs, or?
We may have work in pairs if there's a fellow who's the doctor in training.
Okay. Do you recall on these two if you were by yourself or if there was someone else assisting you?
I had someone else assisting and supervising.
Someone was assisting you, you were supervising, or
No.
did I get that back?
No. I was the one being supervised
Okay.
by another doctor.
Can you tell us the name of the other doctor?
Yes, for which case?
It's a totally good point. Why don't we start with Mr. Jones?
For Mr. Jones, it is Dr. Springer.
Okay. And then with the second.
And then for Larry Ordway, Dr. Falls.
Thank you. Also regarding your office, you said you've done 1,800 ballpark
Yes,
autopsies. Your office does cases from other counties too, right? You're from all over the state?
a segment of the state.
Okay.
Yes.
Do all cases that need an autopsy from Jefferson County, did they all go to your office though?
Yes.
I want to turn now specifically to Mr. Jones.
Okay.
You had indicated, you testified about this a little bit. I want to turn back to it specifically on page 5 of your report. You have your report, right?
Yes.
I have a spare copy.
No.
You testified a little bit about this before, about the injuries to the head. You see the spot, it's number 2 there on the report? Okay. You indicate on your report, I think you, well, let me take a step back. I think you told the prosecution that you couldn't determine the exact cause. Right.
Yes,
Okay.
correct.
You use the term, which is a medical term of art, though it's one that I've heard out in the world, blunt force injuries,
Yes.
right? Okay. Tell the jury what does that term mean, a blunt force injury?
A blunt force injury is an injury to the skin or body as a result of an impact.
And when you say an impact, what makes that distinct from a different type of injury?
It can differ from, say, a sharp force wound, which is due to a cutting of the skin.
So in this case, something struck the head or the head struck something?
Yes,
All right. And when we're talking about it, it would have been fairly recent, right? Bruising doesn't last for years and years.
yes, correct.
And you specifically observed bruising in this case.
Yes,
In fact, we saw bruising and you commented on it in your testimony earlier. It's impossible to tell the exact amount of time from a bruise, right? There isn't a magical timestamp on a bruise.
no,
But you can make some conclusions, draw some conclusions, right? Based on the coloration and things like that.
in some generalities.
Okay. For example, you told us that this would not have been after death or post-mortem.
Correct.
All right. So are you able to say to the jury exactly when that bruising or when that blunt force impact would have occurred?
No, I can't say exactly.
But based on what based on your examination, doctor, you are able to tell that it was fairly recent.
Yes,
Okay. In addition to the bruising, you used the word, I think we already talked about contusion, right? You say it's over the left orbit.
yes.
Can you tell us just which part of the head or face we're talking about?
Yeah, the orbit is just generally the area around the left eye.
So when you're saying over the left orbit, I'm using myself, not you. Is that fair? I'm not, tell me if I'm wrong.
That's a
Am
little
I
more,
wrong?
little more up than orbit.
Okay,
Orbit's
So
more,
closer here.
little further down.
Okay. You also observed an abrasion is that like a scrape?
Yes,
Okay. And then, I don't know this word bilateral, over the bilateral forehead. I don't know what that means.
both sides of the
Okay.
forehead.
And also you said on the nose and the left cheek.
Yes,
Is that right? Okay. There's another one that I don't actually know, so you can help me out. A cortical contusion?
that's a bruising on the brain.
Okay. How are you able to determine that that had occurred?
We could see it on examination of the brain.
Okay. When we say a cortical contusion on the brain, can you explain that in normal words?
If we see areas of hemorrhage or bruising, focal hemorrhage or bruising on the brain surface,
So we're talking about the actual surface of the brain itself.
on the brain itself.
Okay. And that takes a certain amount of force, right?
I believe so,
Um,
but I can't say specifically how
Well,
much.
I'm sorry.
Sorry.
But that coincided with what you observed with exterior damage to the head as well.
Yes,
It's fair to say it's likely that whatever caused the exterior probably caused the interior damage as well.
yes, it's likely they're connected.
Here today, you're not able to tell the jury exactly what caused that injury to the head,
Correct.
but you do know, and you've testified about the fact that there was a blunt force trauma to Mr. Jones's head.
Yes.
Thank you. I have no further questions.
With respect to Mr. Jones, observing the blunt force trauma, there's still, is there any question in your mind as to what the cause of death was?
No,
And what was the cause of death?
the cause of death was due to the gunshot wound.
And would the trauma to the head be consistent with an unprotected fall on pavement?
It can't be excluded.
With respect to Mr. Ordway, we went through some photographs with the jury, but we didn't show all the wounds. Can you just refer to your report and explain where you observed each one of the wounds?
Wounds were seen over the chest, the abdomen, the pelvis, the inguinal region, the back, the left inguinal region as well, the genitalia and the right leg.
And what is the inguinal region?
The inguinal region, to, I guess in lay terms, is the groin.
And so he was stabbed in the groin?
Yes.
How many times?
There was one stab wound to the right groin and one to the left.
And when you say stab wounds to the external genitalia, what does that mean?
That is generally, in this case, talking about the penis and scrotum region.
And when you add all those stabbings up, what number did you come to?
For total in his
Yes.
body, there were 21 stab wounds total.
And were you able to determine the decedent's age at this time?
Not at the time of autopsy.
Do you know necessarily who you're working on at the time of autopsy?
He was unidentified at the time of autopsy,
And subsequently,
and then subsequently identified by the coroner's office.
thank you.
Any requests?
I have no further questions.
Okay, thank you for being here. You're free to go.
Okay, thank you.
Council, can you approach for a moment?
Now, I suspect they're going to be talking about whether or not they should go ahead and do lunch or start another witness, because it will be going on.
We're going to go ahead and break for lunch before calling any more witnesses. I'm just going to ask you to be back in front of the courtroom doors no later than 1:00 p.m. In the meantime, please recall my earlier order. You're not to do any research on this case or post any information about this case. Thank you.
1:00. So that's gives them 69 minutes for lunch. Let's see. What I've got in my playlist. I can't remember if I came across some material on this case.
All right, we'll be in recess until about 5 till 1.
Okay, I found a 20-minute video. Let me just check and make sure that it's suitable here. Just a sec. Let me mute this just in case there's some music or something. Just a sec. Okay, it looks good. It's from a local news station. So this is from 2 years plus ago, and it'll give us some good information on the backstory of the crime. So let's take a look. Here we go.
Thanks for tuning in. In this video, we are going to take a look at the story of Brice Rhodes. You may have seen him online before. Some of his courtroom shenanigans have gone viral. He has a pending trial for the murder of 3 individuals on 2 separate occasions, including 2 teenage boys. It's a pretty incredible and also pretty gruesome story, so stay tuned for that. And I just passed 1,000 subscribers, and I am so amped about that. Thank you to all of you who have subscribed, liked, commented. You guys help to keep this channel going, especially you loyal, longtime viewers, you know who you are. With that said, let's keep it moving.
You think he should be executed?
Yeah. Your job is to do your job, not to worry about me. That's what I'm saying. Well, I worry about me. You worry about yourself.
Every motion I filed, you didn't deny it.
I'm pretty sure I've denied the vast.
Every motion I
majority of
filed?
pro se motions that have ever
Are you
been
some
filed.
type of racist? Huh?
Motion.
Are you a secret Ku Klux Klan member?
No, sir, I'm
Is that
not.
what you really are?
The anger still builds up in your soul.
And it's that anger
Ain't nobody gonna sit in court and hold their composure and have a demon turn around and laugh about them killing your kids. He's a demon. He kills kids.
On May 4th of 2016, as a man named Christopher Jones stood on the 800 block of South 41st Street in the Louisville, Kentucky neighborhood of Chickasaw, not far from the Ohio River, he suffered a bullet wound to the chest and fell in the street, mortally wounded. His assailants fled. He survived only for several more hours and died at a local hospital. A couple of weeks later, on Sunday, May 22nd, a 911 dispatcher received a call after which police arrived at an abandoned home on the 4000 block of River Park Drive in the Shawnee neighborhood of West Louisville. There, they found two boys named Larry Ordway and Maurice Gordon in the tall grass of the vacant home's backyard.
The bodies of Louisville teenage brothers Larry Ordway and Maurice Gordon were found in an abandoned lot in West Louisville. Detectives say the teenagers had been stabbed, tortured, and set on fire.
It looks like they're deceased and they've been burned.
This is the 911 call from a woman who discovered a horrific sight.
Those are kids. Those are kids. Huh? No, they're kids. And it hasn't been that long.
Through the wooded area of abandoned homes in the 400 block of River Park in West Louisville, we see the horrifying images of two bodies.
There's some shoe prints right here, too. There's some good shoe prints, too.
Your view, LMPD responding officers' body cameras.
Before the bodies were discarded and set afire, the boys had been beaten, tortured, and stabbed to death. Maurice Gordon was 16 years old. His brother, Larry Ordway, was only 14. Investigating officers were informed that Larry and Reese had last been seen on the day before, Saturday, May 21st, leaving home with two other teenagers and a man named Brice Rhodes, who was 25 years old. Brice apparently had dated the boy's mother. Apparently, the boys looked up to Rhodes and spent a lot of time with him. Rhodes, also known as Rambo, an aspiring rapper, had featured the boys in music videos where the young teenagers mugged for the cameras and brandished pistols. On the day after the discovery of the bodies, police located one of the boys who'd been seen with Larry, Reese, and Rhodes. His name is Anwan Carter, and he was 14 years old then. They continued searching for Rambo and found him the next day, Tuesday, May 24th. Another individual, who had been identified as the other boy who was with Reese and Larry when they were last seen, was picked up a short time later. This was Jacory Taylor, who was 17 years old at the time. Brice, Rambo, Rhodes, and Jacory Taylor spent hours in police custody speaking separately with detectives about Larry and Reese. Police showed Taylor crime scene photos of the brothers. Taylor said he was friends with the brothers and denied any involvement in their deaths. Rambo told police he had no knowledge of the boys' whereabouts and eventually asked for a lawyer.
I need a lawyer, man, if you're going to keep all in my face. I need a lawyer. I don't want to say, I'm tired of y'all questioning about something. I don't know where y'all getting at. What's going on. I just need a lawyer.
Rhodes and Taylor were arrested and charged with murder and other felonies.
This is one of the men charged with their murders, Brice Rhodes. Through hours of footage, detectives say Rhodes enlisted the help of Jacory Taylor and Anwan Carter, both under 18 at the time, to help kill Gordon and Ordway.
Anwan Carter's disposition towards the officers was quite different. In 2 separate interviews with police, first, he went with the other boys to Rhodes' apartment. He said they all went there because Rhodes had become suspicious that Larry and Reese might snitch to the police about something they'd seen on the night of May 4th. Carter was also a witness to what happened that night and described to police what he saw.
They seen somebody just falling in the street, and they said Rambo said catch the street and shot him. And Maurice, he was a getaway driver, so he was driving.
Did you all drive by him to make sure if he was the right guy, or did Rainbow just basically shoot the first guy you all came upon?
He just shot the first guy we saw. Rambo shot him, he threw the like arm out the window.
Carter says this man, Brice Rambo Rhodes, was in the car in front of him. He says he saw Rhodes pull out a gun and shoot Christopher Jones as they were driving by. Carter says he was driving in a truck behind them.
He fell in the street, and then I drove after him. Where you move?
You ran him over?
He fell in the street with no purpose.
Carter tells the detective teen brothers Larry Ordway and Maurice Gordon were in the car with Rhodes. He says Rhodes was getting paid to kill Jones and was going to split the cash with the teens.
Did he tell you he would split it with you?
He's going to split it all of us.
Did he say how much it was?
10 bands.
I'm sorry?
10 bands, 10,000.
Carter says they never got paid. He says one of the brothers, Maurice Gordon, told his mom about the murder. 2 weeks later, the brothers were dead.
As it turns out, Christopher Jones was not the man who'd been marked for murder. If Carter's story is correct, and Brice shot Jones to collect on the contract that had been supposedly put out for his assassination, then Jones' killing was a case of mistaken identity. Carter also told police what happened at Rhodes' apartment on the night of May 21st.
He made Maurice on his knees and like begged for forgiveness. He tied him up, tied him up with something. He tied his brother up. He made his brother see the bad food.
Carter says Rhodes put a stocking over 16-year-old Maurice Gordon's head, gagged him, and stabbed him in the chest.
And he put a toboggan over his head, and he put a rag in his mouth. And he stabbed him.
Carter says he and another teen, Jacory Taylor, helped Rhodes move the body, then brought the other brother, 14-year-old Larry Ordway, into the living room.
We moved Maurice to the side, and we brought his brother, and we put the toboggan over his head. He put the toboggan in his head, he put the sock in his mouth.
Carter tells detectives Rhodes threatened him, saying that's why he helped stab one of the brothers. He says Jacory Taylor stabbed the other brother.
What happens next? He puts them in crates.
Carter says while Rhodes went to dump the bodies, he and Taylor cleaned up the crime scene.
He left me and Corey at the house to clean it up. He said, sit there and watch them burn.
Oh, should have bought Dixie. These weak store brand plates are risky business.
In one of Carter's interviews, he said that there were at least 2 other older individuals present at Rambo's apartment that night, along with himself, Jacory Taylor, and Rambo. Carter told police that the 5 individuals took a vote on what Reese and Larry's fate would be. Carter said that he was the only one who voted to let the boys live.
He said, should we kill him? I said, nah. I said, just take him home. But I guess I was outvoted, so.
In November, a 4th individual, Tyrone Coleman, 19 years old at the time, was arrested and was later indicted for participating in the killing of Maurice Gordon and Larry Ordway.
19-year-old Tyrone Coleman was booked into Metro Corrections today. Police arrested him after he was indicted in connection to the May murders of teen brothers Larry Ordway and Maurice Gordon. Police are not saying what role Coleman played in their death.
Authorities have not named any other suspects in the case. Prior to his current dire legal predicament, Rambo has had several other entanglements with the criminal justice system. When Brice was taken into custody on May 24th, he was arrested under probable cause of an outstanding domestic abuse warrant derived from a case in Indiana. He is also a registered sex offender in the Hoosier state. One judge has said that he himself has convicted Rhodes of multiple felonies in Kentucky. At the time that Rhodes allegedly killed Christopher Jones, Reese, and Larry, he was on probation for domestic assault, court records show. In addition, he had a pending case consequent to a 2014 incident in which his mother alleges that he grabbed her by the neck and punched her in the temple as she attempted to unload groceries, prompting his teenage sister to call police, according to an arrest warrant. Since Rambo's arrest on May 24th of 2016, his case has been delayed for years. Rhodes himself has been accused of creating some of the holdups intentionally by attempting to fire and replace his lawyers, and also because of recurring infractions and felonies he's committed while locked away. In that time, he's become a minor internet celebrity because of his outrageous behavior during court proceedings, multiple videos of which have been viewed millions of times online. Prior to a hearing on May 31st, Rhodes' attorney informed his client that he would have to recuse himself because of a conflict of interest. He broke the news to Rambo in a holding cell. Rhodes became angry and spat on the man. A deputy separated the two. In the courtroom, the two continued to exchange words.
Nice cheap shot. You a coward. Nice cheap shot.
I'll see you when I get out. McLeod says he isn't afraid of the threat.
In July, Rambo was indicted by a grand jury for the murder of Christopher Jones, Maurice Gordon, and Larry Ordway. Over the course of the next couple of months, he would allegedly assault and threaten to kill a fellow inmate, and in a separate incident spat on another detainee. Both incidents were apparently caught on surveillance cameras. When Rambo entered the courtroom again in September, he was wheeled in, strapped to a restraint chair, and fitted with a spit mask as a precautionary measure. He was quite angry at the circumstance and let Judge Amber Wolf know how he felt.
I think you know why. You know exactly why. Now, listen, stop talking. Have been. Are you done?
No, I'm done.
You've been charged in the 4th degree. I'm going to keep talking because I don't want to have to see you back here for this.
What you think where you live at? What you think at? None of that. I ain't do.
So you're saying you're going to find out where I'm out?
None of that. You got something, I'll be out.
Okay.
Yeah,
You've been charged with assault in the 4th degree, minor injury, terroristic threatening in the 3rd degree with physical contact. New charges. I'm entering a plea of not guilty on your behalf. Would you like me to read the arrest warrant to you?
No, I'm not guilty.
I just said that.
Not guilty.
I just said that.
I'll be out.
I'm going to appoint the public defender's office. Ms. Shoring, that was a threat against the court. I think that I'm asking the county attorney's office to take that into account and consider what to do with that.
Rhodes would later have charges of terroristic threatening and intimidating a participant in the legal process directed at him for the incident. Weeks later, Rambo would allegedly threaten to kill a corrections officer, bringing additional charges of terroristic threatening. And days after that incident, he allegedly threw urine at a corrections officer through his cell door, precipitating assault charges. He pleaded not guilty to the murders of Jones, Ordway, and Gordon in November. That same month, Anwan Carter pleaded guilty to lesser charges and agreed to testify at any trial against any of his co-defendants. In January 2017, Rambo attempted to escape from prison, according to authorities. According to officials, a Metro Corrections officer noticed a man-made hole under cinder blocks in Rhodes' cell on January 5th. Officers say that as they tried to confiscate a metal object from Rhodes, he grabbed it and flushed it down the toilet. Charges of criminal mischief, second-degree escape, and tampering with physical evidence soon followed. The following month, Rhodes was charged with third-degree felony assault for slapping a male nurse in the face during an examination at Metro Corrections. In May, prosecutors announced their intention to seek the death penalty in the Rhodes case. Terrence Coleman accepted a plea deal in July, admitting to facilitating the killing of the boys and the disposal of their bodies, lesser crimes than the murder charges he initially faced. He was later sentenced to 10 years incarceration. At some point in 2017, while Rhodes and Jacory Taylor were both being housed at Metro Corrections in Louisville, Rambo managed to pass a note to Taylor. Among other statements in the note, Brice allegedly told Taylor that, quote, rats get exposed, unquote. The letter continues, quote, show me you my nigga and you ain't no rat, unquote. Rhodes then allegedly told Taylor in the letter he wanted him to recant his statements told to police. He provided Taylor with a letter to copy in his own handwriting, which listed numerous reasons that Taylor could use to take back the statement he made to police. Rhodes allegedly said in the letter, quote, they're going to offer you something to testify against me. The author of the letter tells the young man to stay focused and expresses love for him. The notes were not signed by Rhodes. In January 2018, Jacory Taylor pleaded guilty to multiple felonies reduced from the original murder charges. That same month, Larry and Reese's mother, Elizabeth Marie Wren, attended a hearing for Rhodes, at the end of which she lunged at her boy's alleged killer as he was being led out of the courtroom. Rhodes has told detectives during interviews that he once dated the woman. This is apparently how he got to know her sons. At a hearing in November of 2018, Rambo's courtroom antics continued.
Can we do a fair trial in Jefferson County? But then another part of it is, if we have a concern, what's the alternative? Because then if we might get into a situation where I'm supposed to weigh the pros and the cons. Ma'am, stop it. Look at me, ma'am. He keeps tired. Ma'am, I told you once before. Let me please help you understand. You can't just talk out like that, okay?
This led to an exchange of words between Rhodes and Judge Cunningham.
Mr. Rhodes, you're smiling. I don't know why you're smiling.
Because I can.
Well,
because I can. It's not a crime to smell.
It's not a crime.
Continue what you were saying.
But it doesn't help you, all right, to irritate people.
All right.
And you have a lot at stake in this case.
It's not a crime to smell, is it?
I didn't say you were committing.
Okay, then.
I'm saying you're not helping yourself.
Continue what you were saying.
I'm
allowed to smell.
I would suggest you do what helps you, not what hurts you.
Okay.
That's
what I want to do.
Well,
Let's
do
get
what
that
you want to do.
understood.
That's fine.
Let's get that understood.
I'm sorry.
Let's get that understood.
Well, you made that.
Continue what you were saying.
In March of 2019, Rambo threatened another corrections officer, according to an arrest document, which says that he told the man he and his family would die. He also told the officer he would be shanked in the face and would not see it coming, according to the document. In October of 2019, Rhodes attempted to have his then attorney removed from his case. This was the third lawyer that had been assigned to him. He directed some sharp words at Judge Cunningham during one exchange over who would represent Rhodes.
They're not trying to give me a fair chance, effective counsel.
Well, who do you think I should
It's
give you as
okay.
a lawyer?
I'll write the Bar Association and the ACLU. Your job is to do your job, not to worry about me. That's what I'm saying. Well, I worry about me. You worry about yourself. My thing is, he needs to be removed from my case.
At a pretrial hearing in March of 2020, Rhodes attempted to have his case thrown out, saying, as he had at prior hearings, that investigating officers had previously perjured themselves when presenting evidence. Judge Cunningham denied the motion. Rhodes was upset at the ruling and let the judge know how he felt.
You think this is the best?
Even though you show favoritism to the Commonwealth, you denied every motion I've ever filed in this courtroom. I'm still it's my right to file a pro se motion, and it's my right to speak what I need to speak on. I don't know if y'all got some type of sexual relationship going on or what y'all got going on, but I'm definitely going to speak my mind.
Detective Patelli and I have no sexual relationship.
Now I'm talking about you and the prosecutor over there, sir.
All right.
You denied all my motions. Every motion I filed, you did deny it.
I'm pretty sure I've denied the vast
Every
majority
motion
of
I filed.
pro se motions that have ever
Are you some type of racist? Are y'all got some type of sexual relationship going on? Which one is it?
Or are you just wrong in everything that you've made a motion for?
Are you a secret Ku Klux Klan member?
No, sir, I'm
Is that
not.
what you really are?
Nope.
Okay.
Larry and Reese's grandmother, Debbie Wren, who can be seen on video attending many of Rhodes' hearings, has told the judge in the case and the media that she believes that Brice is simply gaming the system.
Every time you look up, he's trying to get rid of his lawyer. He's just prolonging and prolonging. He's playing the system. That's exactly what he's doing. And this is going on for 4 years. And nothing's been done.
You think he should be executed?
Yes.
Rambo has been charged with no less than 4 additional crimes since his triple murder arrest. According to WDRB in Louisville, Brice Rhodes' trial has most recently been scheduled to begin in January of 2022. Thanks for watching. Hope you enjoyed the video. If so, please like and subscribe. And if you have any thoughts, leave a comment. All of that helps the channel to grow. I don't have a preview of
Okay, wow, I think his grandmother just said he should be executed. That's not going to happen because I understand that the judge found him to have some intellectual disabilities. And so, according to the Supreme Court,
my next video I'm working on,
can't be executed. Let's take a look up on let's see what they said about that. Let's see, and looking, it says back in April, the news story says statewide backlog. It took a state more than a year to evaluate Rhodes on whether he was competent to stand trial or should be eligible for the death penalty. Let's see, on October 27th, we got a news story. Let's pull that up. Let's see. Let's go over here, change the image so that I can read the article. The man arrested for the gruesome deaths of two teams, and a man in 2016 won't face the death penalty. Brice Rhodes was arrested in 2016 for the deaths of Maurice Gordon and Larry Ordway in Louisville. The teens were stabbed to death and then set on fire. Rhodes was also charged with killing Christopher Jones a few weeks prior. Although it was ruled that Rhodes was competent to stand trial on Friday, a judge ruled that he won't face the death penalty for his triple murder trial. The judge said Rhodes was found to be intellectually disabled, in quotation marks, and suffered from a serious mental illness for almost all of his life. That means the harshest sentence that Rhodes will now face is life without parole. Jury selection is expected to begin on December 11th. And so that's that. Let's see. We've got another 42 minutes. Okay, here's another one on one of the accomplices that were minor. Let's see. Let me get this queued up here. Okay. Here we go.
A teenager will stay in prison for now after he confessed to helping murder two of his best friends.
WDRB's Travis Ragsdale explains why he could still be released soon in spite of the brutal crime. Travis?
Anwan Carter admitted to helping Brice Rhodes kill two people, but he's 18 now, and he could have gotten out of jail today, but a judge said no.
I wish the outcome was different. I wouldn't, if I knew this wouldn't happen, I wouldn't have hung out with Maurice and Larry.
That's Anwan Carter. He turned 18 on Tuesday. It was back in 2016 that he confessed to helping Brice Rhodes kill teenagers Maurice Gordon and Larry Ordway.
Put a rag in his mouth. And he stabbed him.
Carter took a plea deal and flipped on Rhodes, agreeing to testify against him. He was sentenced to 10 years. But since he just turned 18, he was eligible to get out on probation, which his attorneys pushed for.
I truly believe that Mr. Carter is a victim of Brice Rhodes, along with everybody else. All these kids, I think, were basically influenced by him, and obviously to a horrible degree.
But Gordon and Ordway's family begged a judge to send him to adult prison.
You could have saved them their lives. You could have saved them. But did you? No, you did not.
And Judge Charles Cunningham agreed. Cunningham ordered Carter to continue his sentence.
Fairness in this case would probably say, we need to put a needle in your heart. That's the only fair way to resolve. Justice, however, doesn't necessarily mandate that we kill you, much less keep you incarcerated for any particular period of time.
But because Carter has been in juvenile jail for 2.5 years, he's already eligible for parole. As for Brice Rhodes, he has to face those 2 murder charges as well as another at his trial scheduled for July. We're live in downtown Louisville. Travis Ragsdale, WDRB News.
Travis, thank you.
Spit on and threatened. The defense attorney says that is what happened when he told a high-profile murder suspect he'd no longer represent him.
WDRB's Rachel Collier shows us what happened in front of a judge. Rachel?
Brice Rhodes is here in jail charged with killing 2 teenage brothers, and now he'll need to find a new attorney. Before the hearing started, attorney Brendan McLeod told the judge he was so angry he needed to be separated from Brice Rhodes in court. McLeod tells WDRB he was speaking with Rhodes before the hearing, explaining he would no longer represent him. He says everything was calm, and then Rhodes spit on him. After Rhodes was led into the courtroom in his red jumpsuit, marking his protective custody, McLeod let him know how he felt about being spit on.
Nice cheap shot. You a coward. Nice cheap shot. Coward.
I'll see you when I get out. McLeod says he isn't afraid of the threat. McLeod took on the case because he knows Rhodes' mother. He stepped away because he learned the victims, 14-year-old Larry Ordway and his brother, 16-year-old Maurice Gordon, are the grandchildren of his close friend. The 2 brothers were found stabbed to death, their bodies badly burned earlier this month. Rhodes is charged with murdering them. 2 juveniles are also charged in the case. We're also learning more about the teens' murders. Homicide detectives now telling us they were killed at Rhodes' apartment in the Clifton neighborhood. Police say the bodies were taken from the murder scene and dumped behind a vacant home in the Shawnee neighborhood. Rhodes told a judge this morning he'll find another attorney. Leaving court, he had a question. He'll need $2 million to get out of jail. Rhodes is also charged in the shooting death of Christopher Jones in early May. The 2 teens' mother says she believes her sons were killed because they witnessed Jones' murder. The funeral for the 2 brothers is ending right about now. McLeod says he attended the visitation earlier this afternoon. Reporting live from Metro Corrections in downtown Louisville, Rachel Collier, WDRB News.
Thanks for tuning in. In this video, we are going to take a look at the story of
Okay, we've still got over half an hour to go. Let's see. Oh, interesting. I just noticed that it says 2 of my videos are hidden, which are on my potential playlist for show. Okay, let's see. Okay, let's watch this. The 5 wildest outbursts from high-profile trials. Let's get this queued up.
For the majority of the trials that we cover here on Long Crime and Sidebar, usually everything remains relatively calm, but there are moments when that just doesn't happen. So we want to revisit some of these intense courtroom outbursts, and we're going to start with the trial of Scott Nelson. Scott Nelson was convicted of the murder of nanny Jennifer Fulford after he robbed a home out in Florida and then kidnapped her, and he admitted on the stand that he killed her so there wouldn't be a witness. Just such an evil, evil crime. But then it became a matter of what should be his punishment, life in prison or the death penalty. And during the penalty phase of the trial, Roy Gravett, a federal prison expert, came on the stand, and he testified that Nelson had problems with Muslim inmates while behind bars. Well, Mr. Nelson didn't quite like the way that he was being portrayed, and he let everyone know about it.
Court, can you read back the question?
Mr. Nelson has shown no adverse effects for the special housing.
Mr. Nelson, you need to take a moment. Mr. Nelson, you need to take a moment with your attorneys. Hold on, sir. Members of the jury, Mr. Nelson. Mr. Nelson, are we clear that you're going to stop talking? I need a verbal affirmative. Mr. Nelson, talk with your attorneys, and then your attorneys. Mr. Nelson, Ms. Simmons has asked for a moment to talk with you privately. I'm going to grant her request, and you're going to have that opportunity. You need to follow the deputy's instructions so they can facilitate this. Okay, go ahead.
What makes a person a murderer? Are they born to kill or are they made to kill? Well, Killer Psyche Daily is a new podcast that gives you a quick 10-minute rundown every weekday on the motivations and behaviors of the criminal masterminds, psychopaths, and cold-blooded killers that you read about every day in the news. Host Candace DeLong draws on her years as an FBI agent and criminal profiler to break down these cases for you. On Killer Psyche Daily, Candace will give you insight into cases like Ryan Grantham, the actor who killed his mom, and of course, the Stockton serial killer. She's also going to invite expert guests to dive deeper into the details and share what it was like to work at Quantico. She's also going to answer some killer trivia and even host a virtual Q&A that allows you to ask her questions. It is a unique show with unique insights for all true crime followers out there. So Amazon Prime members, listen to the Amazon Music exclusive podcast, Killer Psyche Daily, in the Amazon Music app, and you can download the app today. He interrupts the testimony in his seat. That is so not allowed. The attorneys can make objections. He can't say anything. And isn't it just so wild that he wants to proclaim he's not a racist? He had no problem saying he's a killer, but as long as everyone knows he's not a racist. Oh, okay. Interestingly, I should tell you that Nelson asked the jurors to give him the death penalty, and they actually sentenced him to life in prison. By the way, it's very common for defendants to not be happy with what's being said in court, either to them or about them. But that does lead me to one other outburst that almost evolved into something much worse. It is the Florida penalty trial of Besman Okafor, the man convicted of murdering 19-year-old Alex Zaldivar, with prosecutors saying he executed the teen to prevent him from testifying. And at a Spencer hearing, which under Florida law allows defendants to present additional evidence when determining a sentence, Zaldivar's father took the stand. And as you'll see, he makes comments directly to Okafor that the murderer didn't like.
I've run out of adjectives. I don't know what to say to this man anymore. But today will be the last time that I will get to see him. But I will see you in 10 years.
Objection, Your Honor.
Thank you very much.
Mr. Zaldivar.
Now, please.
Please, sit down. That's
Let's take him outside for just a moment. Mr. Asher, you can take that photograph.
So you have Mr. Zaldivar saying directly to the defendant, "You're dead." And then Bessman cursing and saying, "I'll show you how gangster I am." He was removed from the courtroom. And I'll tell you, if it wasn't for the special response team of Orange County Sheriff's deputies, who knows what could have happened in that courtroom. Little side note here, Okafor was sentenced to death, but that's kind of up in the air given how Florida changed their laws, which now requires a unanimous jury vote for the death penalty. But either way, what a moment. Now, sticking with the theme of angry defendants for a second, let's go to Darrell Brooks. Again, we talked about him extensively here on the program. The guy convicted of killing 6 people, injuring dozens of others after driving his car into a holiday parade out of Waukesha, Wisconsin. And as I've mentioned on the show before, Brooks, who decided to represent himself, got into major fights with Judge Jennifer Darrow, particularly since he would bring up irrelevant legal theories and would constantly complain that his rights were violated, and he just was overly disruptive of the proceedings. And yes, the arguments got intense at times, but no point was as bad as this. I'm going to give you a little bit of a setup here. What you're about to hear and see comes off of Brooks saying that the prosecution wasn't playing fair. He made a baseless accusation that the state was coaching witnesses, and he was getting more and more angry. And then this happened.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one.
Mr.
I got one
Brooks.
ear that work, and I heard that.
This
Come on,
is to benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me. So let's
has
be
a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for
Lescott.
that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I set the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I
can you
believe he
please-
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared.
Wow. I mean, when have you heard a judge stop in court because of that? He slams his fist. He just stares her down. The level of patience that Judge Darrow had during the course of these proceedings is pretty remarkable. And I said it before, I'll say it again. When people say, how come she didn't kick him out of the courtroom more? Why did she give him so much leeway? I was of the opinion that I think she wanted to ensure that she gave him every opportunity and every chance so that when he was convicted, which he was, he couldn't muster any kind of argument like the court was unfair to him. Just unbelievable. By the way, one more angry defendant that we have to address, Alex Jones. Now, again, another case we've talked a lot about here on Sidebar. Well, Alex Jones had 2 trials that we covered, one in Texas and one in Connecticut. The InfoWars host was sued over comments that he made that the Sandy Hook Elementary School shooting was fake and that it was staged. And when he testified in his first trial in Texas, he took the stand and said that he didn't intend to harm anyone. He seemed almost apologetic, says that the shooting was 100% real. But then after being hit with an almost $50 million judgment, you have to wonder if something changed, because when his Connecticut trial happened later, some would say perhaps the real Alex Jones came out, or at the very least, a different side of Alex Jones.
That's Robbie Parker, isn't it, Mr. Jones? It is. That's the real Robbie Parker, isn't it?
I mean, I said years ago, I thought something would happen.
Robbie Parker's sitting right here. He's real, isn't he?
Yes.
And for years, you put a target on his back, didn't you?
Objection to the form of that, Judge.
Well, I mean,
Didn't you?
I've said his name. It's true. I haven't said other people's names when they are.
You put a target on his back, just like you did every single parent and loved one sitting here, didn't you?
No, I didn't.
No, you didn't.
That's argumentative. There's speculative. There is no foundation for it, and it's inappropriate to this time.
These are real people. You know that, Mr. Jones?
I think you just told them to move on.
Just like all the Iraqis, but you liberals kill and love. You're unbelievable. You switch on emotions on and off when you want. It's just ambulance chasing.
Why don't you show a little respect?
Objection, Judge. I think that you get what you give in this court. Objection.
You have families in this courtroom here that lost children, sisters, wives, moms.
Is this a struggle session? Are we in China? I've already said I'm sorry hundreds of times, and I'm done saying I'm sorry. I didn't generate this. I wasn't the first person to say it. American gun owners didn't like being blamed for this, as the left did. So we rejected it mentally and said it must not be true. But I legitimately thought it might have been staged, and I stand by that, and I don't apologize for it.
And don't apologize, Mr. Jones. Please don't apologize.
No, I've already apologized to the parents over and over again.
We know
I don't apologize to you.
Objection.
Don't apologize to you.
You're going to do it again.
Objection, Judge.
Aren't you?
Objection.
No, I'm not.
Objection. Argumentative.
Don't apologize to you.
Well, it's hard for me to get a word in edgewise.
It is, but I
Because
think
your
there's
client
one
is-
officer of the court and one witness and an officer of the court heard the objection.
And I can't rule on your attorney's. Excuse me.
I'm sorry. Just wait a minute.
This is a farm. No, really, this is a farm. So is this, and this. Inside these.
Now, I will tell you, I'm not sure him acting any different would have changed the outcome of this case. In this case, he was hit with an almost $1 billion damages judgment. But what this part does is it really highlights some of the things that Jones was saying on his program. And some believe that this was all an act, that he was really pacifying his audience of followers, that this was all a show trial for him, and he was just trying to stand up to his enemies. All right, I couldn't talk about the most memorable courtroom outbursts without talking about one that is unlike anything else. This was during the sentencing hearing for Larry Nassar, the former physician for the USA Gymnastics and Michigan State University, who sexually abused hundreds of girls. Well, during a sentencing hearing out in Michigan, Randall Margraves, the father of 3 girls who were abused by Larry Nassar, asked the judge for a favor. And as you'll see, things erupt into chaos.
Judge, would a distraught father have a chance to say something? You son of a...
We don't want to swear. We don't want to have profanity. I can't imagine the anger and the anxiety and the feeling of wanting retribution. And if you need to say something to help you, I'm more than willing to let you say something. But in a courtroom, we don't use profanity. But if you have some words that you would like to say, I would like to give you the opportunity to say.
I would ask you to, as part of this sentencing, to grant me 5 minutes in a locked room with this demon. Would you do that?
That is not.
Yes or no?
No, sir.
Would you give me 1 minute?
You know that I can't do that. That's not how it is.
Well, I'm going to have to get...
What's happened to you guys?
Just make a comment here that I was reading years ago about some, I think it was a burglar who'd come in and rob people's homes, and they judged it kind of an unconventional sentence, and he allowed the victims to go into the convicted guy, thief, into his house and have 15 minutes to do as they pleased with his house. And thought that was a rather novel sentence. So, okay, let's get back to it.
Not behave like that. No one can behave like this. I want to make sure it's crystal clear. I'm sure Judge Craig.
You haven't lived through it, lady.
You cannot behave like this. This is letting him have this.
Yeah, I've never seen that before. That's why courtroom deputies are so important. In fact, the judge had to weigh whether imposing a contempt of court charge on him, and she ultimately denied doing so given the circumstances of the case. Margraves did apologize to the court. He said, "I lost control. I apologized 100 times. I'm definitely calmed down. I'm embarrassed. I'm not here to upstage my daughters. I'm here to help them heal." So yes, completely wrong for him to do, but also completely understandable why he chose to do that. All right, everybody, that's all we have for you. Thank you so much for joining us here on Sidebar. Please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.
All right, let's see. We've still got 20 minutes to go. So let's take a look. Okay, let's go. The next video I've got in my playlist here, the top 5 5 times defendants represented themselves in trial. So
You will have the sole responsibility to cross-examine witnesses, to present evidence, to make arguments to the court, etc. Did you hear me say that?
Yes, ma'am.
And you're informed of all of that?
I am informed.
Objection, Your Honor, asked and answered, and we've gone down this path.
Mr. Smith.
Objection. And I'm standing here competent as can be, representing myself today.
From screaming at a jury to sparring with a judge to mentioning Scooby-Doo in an opening statement, these are some of the top times defendants represented themselves at trial in recent cases. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. It's sometimes hard to imagine how someone could represent a defendant, right? A person accused of some of the most heinous crimes that we can think of. Well, I guess it becomes easier when the person representing the defendant is the defendant themselves. Yeah, defendants taking matters into their own hands, acting as their own lawyer in a trial. I will tell you, always interesting to see. And that is what we want to get into, some of the top times a defendant represented themselves in recent cases. Now, as we go through all this, I want you to keep in mind a phrase. The phrase, "A man who represents himself has a fool for a client." Now, why am I saying that? Well, maybe what better place to start than with Darrell Brooks Jr. He's the man who drove an SUV into a Christmas parade route in Waukesha, Wisconsin, killing 6 people, wounding dozens of others. This happened back on November 21st, 2021, and he ended up facing numerous charges, including 6 counts of first-degree intentional homicide. So during his criminal trial in 2022, Brooks' antics went viral multiple times, from him taking off his shirt to him building a fort out of boxes to staring down the judge. But we want to take you through the decision to represent himself and how that all worked out. So despite the gravity of the charges against him and the magnitude of evidence, Brooks told Judge Jennifer Darrow that he wanted to go pro se, meaning represent himself, as is his legal right. And this clip kind of gives you a pretty good idea of what was to come in this trial.
You want to represent yourself.
Yeah, but I didn't file the motion.
That's
I'm just
not
merely-
relevant,
I'm just
sir.
merely
The motion is
asking-
before
I'm
me,
just
and I'm
merely
going
asking-
to address it.
I'm
Stop
just merely
talking
asking
over
the
me,
question.
Mr.
That's
Brooks.
it.
Just merely asking.
I
a
need
question.
to get through the advisement.
And I would like to know the answer to the question that
You are
I'm
being
asking.
difficult. You are not listening. You are trying to interject irrelevant factors for this court.
It has
So,
merit.
stop.
It's not irrelevant.
Stop.
I have a
Mr.
constitutional
Brooks,
right to
I'm
be able
going
to
to
ask questions.
continue. Please stop talking.
So it is a rush to judgment.
Mr. Brooks. The case law makes very clear you can't waive your right to an attorney. Let me rephrase that. The case law makes clear you cannot act as your own attorney, right? Exercise your right of self-representation while simultaneously exercising the right to counsel. Did you hear me say that?
Yes, I heard you say that, but that wasn't what I was attempting to do. That was the whole reason why I said it was filled out. This form was filled out for a specific reason, the way that it was.
Sir, I'm not going to entertain a request for whether it be called standby counsel, hybrid
That's not what I'm talking
representation.
about.
Your attorneys have told me you want to represent yourself. That is why we are having this hearing here today.
All right, we want to thank Morgan & Morgan for sponsoring this video. You know, life's scary, minding your own business when it seems that everyone and everything, no matter where you turn, seems to want to hurt you. Okay, maybe that was a bit much, but you get the idea. The point is, you don't have to feel helpless because Morgan & Morgan, the largest injury law firm in America, is here. Now, before you say, oh, great, another law firm ad, first of all, how dare you speak that way of Morgan & Morgan? And second of all, you don't know what makes them special. Brooks just wanted to do this to delay the trial.
I want you to know that waiving your right to an attorney does not mean the trial is delayed. Did you hear me say that?
That's not my reason for wanting to represent myself pro per. It had nothing to do with delaying the trial.
So you don't want to delay the trial, correct?
That's not what I said. I said that the decision to represent myself pro per had nothing to do with a delay tactic. I think I'm very clear with what I said.
Well, I want to be clear. I understand you, sir. If it's not a delay tactic, I take that as you're not requesting an adjournment of the trial. Is that true?
That's not what I said.
Are you requesting an adjournment of this trial?
I can't logically make that decision until you make a judicial determination. Why would I answer that question right now at this point when I still don't know what's been decided yet?
So here's the important takeaway, in my humble opinion, sir. You are being advised that I am not going to adjourn the trial that is scheduled to start next week. Did you hear me say that?
I heard you say that. And
knowing that, sir,
I still can't logically answer what you are asking me because a decision has not been reached.
sir, what you need to understand is that the case law makes it very clear you have the absolute right to represent yourself. That is protected by the US and the Wisconsin Constitution. Did you hear me say that?
I know that.
Since not everyone is a total stoner like my husband,
Guilty.
Mood takes the guesswork out of cannabis, so you know exactly.
And Brooks proved time and time again, even during these earliest proceedings, that he wasn't going to be the easiest to work with.
Understands that a lawyer may be appointed if the
I never
defendant
said I
is
understand.
indigent and understands the disadvantages of
Never once said
self-representation.
I understand.
He is voluntarily and freely waiving the
As a
right
matter
to
of
be
fact, I do not
represented by
understand.
counsel and is making a deliberate choice to proceed without counsel. And therefore, the court will grant the motion to withdraw brought by Attorney Perry and Attorney Keys. And from this point forward, Mr. Brooks will proceed as his own attorney.
And if the court thought that Darrell Brooks would behave more professionally as things got underway, they were wrong.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record. that
Mr.
I'm not
Brooks,
identified by the
it
name
wasn't
that
the
you called me
proper
by, that's
time to
all.
do that. That's now the third interruption. So,
With all due respect, Your Honor, every
Mr.
time
Brooks,
we,
by
every time
saying
we,
all due respect doesn't change the fact that you're interrupting me. Your objection is noted. All right, but you need to stop interrupting me so I can get through what needs to be done.
but it is
I
my
have a
right
number
to-
of documents
it is
that I
my
need
right
to discuss
it
this
is my
morning.
right to-
Mr. Brooks, you do not have a right to interrupt the court.
No, it
I
was-
will
that
remind
was
you
not
once
my
again
intention.
of the Supreme Court rule. It's on a yellow laminated, double-sided piece of paper that is before you. I
did not
checked, I
recognize
verified,
that.
it
I
is.
accepted and returned it to
Mr. Brooks,
value,
that's
Your
yet another interruption. Let me get through this, please.
just want for the
You
record.
will opportunity. No one else
stated-
is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
You heard him say there that he doesn't identify by the name Darrell Brooks. He brought this up multiple times before and during the trial. And that's because Brooks identifies as what's called a sovereign citizen, which seems to mean that he doesn't believe the regular laws apply to him. And while he repeatedly said he didn't consent to being called Darrell Brooks or even Mr. Brooks, you know what I was thinking throughout all of that and that whole trial? I don't recall him ever saying what he did want to be called. Anyway, throughout this trial between Brooks and the prosecution, there were reportedly more than 600 objections. And look, despite this being a really serious case, I got to tell you, it was Brooks's antics in court that at times, honestly, it became comical to watch.
I'm winging it, Your Honor. Respectfully object to
You
that.
can object, your objection's noted, but you need to let her state what she needs to state.
I don't see the relevance of this.
Your objection is noted, it's overruled.
Are you a party to this matter in any way?
Objection
Grounds.
irrelevant.
Grounds.
Sustained, it's not relevant.
Do you have a claim in this matter?
Objection
Grounds.
Sustained.
Have you read the complaint in this matter?
Objection
Grounds.
Not relevant, sustained.
Objection, I do not consent to being called that name, nor do I know any individual by that name, Your Honor. Objection, hearsay, and speculative.
It's neither one of those things.
Can we address the subject matter jurisdiction before the jury comes out? The jury comes out?
We've already done that.
And is that a judicial determination that you're making not to address the subject matter jurisdiction, which has yet to be proven at this point? It has not been
Mr. Brooks,
verified.
please, the jury's coming out.
We gotta cut that out. You know you have to prove subject matter jurisdiction. You know that. Your Honor, I don't consent to being called that name and would like to address subject matter jurisdiction for the record that has yet to be proven.
Comical might be one word. Then again, I think it was exhausting. Yeah, exhausting. I think that's a fair word to describe some of his defense tactics. And Brooks especially sparred with the prosecutors.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be
the-
said. So it's the defendant.
That's not how it was said. I
That was how I
completely
said. You want to
disagree.
run the record back?
Mr. Brooks,
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
this
Come on,
is
man.
to benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of this
your
to benefit me,
witness
so let's be
has
clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for
Liscott.
that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
Judge Darrow even said at one point that Brooks was scaring her when he stared her down. So maybe not surprisingly, she removed him to a separate courtroom several times during the course of this trial so he wouldn't interrupt court proceedings. He could still monitor what was going on. But more shenanigans ensued, with Brooks taking off his shirt, building a fort out of evidence boxes, waving his arms so he could be seen on camera, refusing to wear the headphones so he could actually hear what was going on. But at one point, even Brooks may have realized he was in over his head.
Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say anything about representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things. You, Your Honor, gave me paperwork that was a waiver of counsel. We both know that any contract can be altered if I don't agree to certain terms. I crossed out everything in that paperwork that I did not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel. At the very least, I should have been awarded a standby counsel. Not someone to represent me, to speak for me, but someone to help me do things in a timely fashion, get things filed in a timely fashion, get motions together in a timely fashion, make preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County Jail. I gave you back that paperwork and you accepted the paperwork that I altered, that you understood that I didn't agree and consent to those things that were altered. You accepted it and you filed it.
Yeah, this kind of seemed to me like you can't have your cake and eat it too kind of thing. You want an attorney to file for you, do your paperwork, but you want to do the arguments, right? Seems like he wanted a paralegal, like a legal assistant. And look, under the court's rulings, he forfeited his right to have standby counsel. So it's all on him. He seemed to understand that when he first made the request to represent himself. And by the way, this defendant really pushed the judge to her limit.
Starting with a blank page can be overwhelming. Grammarly gives you a head start. Simply type a prompt to...
All right, the jury's coming back out, and I'm going to warn you, if you bring this up again, I will pause and I will remove you to the next courtroom for being disrespectful, for being interruptive, for being disruptive, and for bringing up irrelevant matters in front of this jury. You will forfeit your right to be present for the direct examination of this witness.
I object to
Did
that,
you
Your Honor.
hear what I said,
No,
sir?
I did not. I object to that, Your Honor.
Well, you can
And
object, and your
you-
objection is noted, but if you
For the
interrupt
record-
when this jury
for
comes
the
out,
record-
they will go, I will have them taken out again, and you will be removed to the next
For the-
courtroom.
You can't, what is the legal basis for that ruling, Your Honor?
Illinois versus Allen, sir, and all of the
And-
other cases that
and it
I've
doesn't
cited
say
previously.
anything-
I'll make the appropriate record. Stop interrupting me. The jury's coming out. We're continuing with this trial despite your repeated efforts to disrupt.
That's a
Yesterday,
mischaracterization
sit
of the
down.
record.
Yesterday alone, sir, 17 interruptions, not including the opportunity that I gave you where you spent 15 minutes, okay, discussing what were primarily either irrelevant or baseless accusations and requests not based in law or fact. I was abundantly patient with you yesterday.
And you still haven't
And-
verified by proof any of what I
And
said,
none of
Your
that
Honor.
is required, sir.
Because it
And
is. You can't verify.
your
it with proof.
belief
Where's
that
the
that's the
subject matter-
law
where's the subject matter
doesn't make it
jurisdiction?
so, Mr. Brooks. Your belief that these are legitimate legal positions
They are.
doesn't change the law and doesn't make it so.
It's
So,
clearly
again,
relevant because you didn't want to.
I'm
address
going
it.
to step off and give Mr. Brooks 5 minutes to cool off.
I'm
And
not-
when that
I don't
happens,
need
I'm
to
bringing
cool
the
off.
jury
I'm not
out,
angry at
and
all.
then we will
I just wanted
continue.
to. I don't.
And this went on for basically the whole trial. Now, to give you a sense of what he actually argued at his defense, here's a sample. Brooks delivered his closing argument, and he got emotional.
I myself in my own life have had to do a lot of healing. As a man with children myself, I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn. While attempting to alert people of their presence.
And he even at one point suggested the jury engage in nullification, which is basically like ignore the facts, ignore the law, decide this case based on some other factor. It is totally improper for the jury to do that, and totally improper for him to tell the jury to do that. And he was instructed not to do so. But he also brought up one of his only maybe real defenses. And that argument seemed to be that the car that he was driving had been under recall and that he had no control over the brakes and was honking his horn to get people out of the way.
Which brings me to more information that I believe that you should have been privy to. And I'm sure that the prosecution will beg to differ. But the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in
Improper
fact-
argument, Your Honor.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford
Objection.
for those
facts not in
model
evidence,
for
Your
those
Honor.
model vehicles.
Sustained, the jury will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know.
But he actually did have the opportunity to question a state patrol inspector on the stand who testified that there was no mechanical issue with the car that would have caused the malfunction, meaning the driver wouldn't have lost control, meaning the car hit those people because of the driver and the driver alone. It also didn't help that multiple people testified they saw Brooks as the driver, and there was video and photographic evidence that he was the driver as well. Well, it took the jury only about 3 hours to reach their decision.
We, the jury, find the defendant.
Free diving is diving into yourself, diving into your fears. The Black Mermaid Foundation's work is to create access to
Daryl E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information. Dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Daryl E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. Hey, you are to be removed right now. You will not do that.
Well, you heard there how someone felt after that verdict. Darrell Brooks was convicted on all 76 charges, including 6 counts of first-degree intentional homicide, and he was handed down 6 life sentences in prison plus 700 years. And he'll go down as being part of one of the wildest trials in law and crime history. Well, this next case definitely needs a warning. The crime here, unthinkable. One of the most brutal that we have ever reported on. So let's go to 2018, where 29-year-old Ronnie O'Neill III beat and then shot his girlfriend, 33-year-old Kenyatta Barron, and hacked their 9-year-old special needs daughter to death with an axe. Her name was Ron Nevea. And if that wasn't terrible enough, he also stabbed their 8-year-old son, Ronnie O'Neill IV, and set their home on fire. The young boy wasn't expected to survive, but miraculously, he managed to recover. In fact, law enforcement testified that they witnessed this young boy struggle to walk out of the home with stab wounds and severe burns. It doesn't get much worse than that. This all happened in Riverview, Florida. When he went to trial in June of 2021, O'Neill decided to act as his own attorney with standby counsel. And when it came time for him to deliver his opening statement, O'Neill took several deep breaths and then launched into a tirade.
The evidence is going to show that we are under some of the most vicious, lying, fabricating, fictitious government you ever seen. By the time it's all said and done, you will see who is the mass murderers. In Tampa Bay, the state of Florida. You will know why what occurred on March 18, 2018 occurred. And the evidence is going to show that law enforcement tampered with evidence to meet their such high burden of proof. Because originally, it wasn't enough. So we had to tamper with evidence. Since it was such evident already, but we still had to tamper with evidence.
Thank you. Debbie, would you mind to come up? We wanted to talk to you about some photos that I might need. Does anybody need to report anything with regards to the admonition? All right, I'll wait just a moment for them to get those items. Thank you. Is Commonwealth ready to call their next witness?
Yes, we have multiple spots.
Thank you. Hi there, good afternoon. You can come right up here to the witness stand. And I will have you raise your right hand, please. You swear to tell the truth and the whole truth? Thank you. You may have a seat.
Please introduce yourselves to the jury.
My name is Jeffrey Scott Doyle.
And where did you work?
I was employed by the Kentucky State Police Forensic Laboratory from 1979 through 2019. I retired in October 2019.
Are you still retired?
I am.
Good. Congratulations.
Thank you.
So in 2016, obviously you were at the lab.
Mhm.
Did you receive some evidence in this case?
I did.
And is this noted with a certain laboratory number so that you can track what you're about to talk about?
That's correct. Every case submitted to the laboratory was assigned a unique lab number. Each item of evidence was assigned a unique item number, and that was all tracked through the system and to keep everything organized.
In this case, before we get to this case, what sort of things did you do at the lab?
Well, primarily I was in firearms. My job as a firearms examiner also included looking at things like tire and shoe prints that's related to this case. It was all a form of comparative analysis. So in firearms, we're looking at bullets and cartridge casings and comparing those microscopically to samples from a gun that may have been submitted. In addition to that, shoe and tire print identification is a form of comparative analysis. So we're looking for both class characteristics and individual characteristics that may exist on a known item that may have transferred to, say, through your shoe prints or through your tire prints. And so that comparative analysis was a part of my job that I did for basically 40 years.
And did you receive training and continuing education to do that?
I did. Early on, back in 1979, I was trained at the Central Forensic Laboratory in Frankfurt to be a firearms and tool mark examiner. That included training from the FBI, gun manufacturers, other forms of training. I was a distinguished member of the Association of Firearms and Tool Mark Examiners, and which we had an annual training seminar that I attended most of the time. And so yes, there was ongoing training, as well as we had peer review. So every case we worked was reviewed by another examiner. The results were examined. So there was a extensive amount of training early, but then there's a lot of on the job, just working cases as well during that course of 40 years.
Did you receive a number of items of evidence in this case?
I did.
How does the lab get the evidence?
The lab would receive the evidence from the Louisville Police Department Evidence Technicians Unit. So whenever something happened, the evidence technicians would go out, they'd collect the evidence, they would package it, they would organize it, and then they would submit it to the laboratory for examination, and then I would conduct my examinations.
In this case, did you receive 2 tire imprint casts?
I did.
What is a tire imprint cast?
Well, the technicians would go out, and at the crime scene, they may see a tire imprint in the ground. And to preserve that and to record it and to collect it, they would mix plaster, a plaster substance. There's different types, but they would pour that into that imprint that was in the ground, let it harden, and then they would collect that. After it hardened, they would pull it up and they would submit that to the laboratory, and it would have the negative image of that imprint. And then that would be used to compare to any, if they had tires, let's say if we're talking about tires, it would be compared to any tire samples they may have, or if it's shoes, they would be compared to any shoe samples they may have.
Did you also receive 2 shoe imprint
I did.
casts in this case? And what did they provide you with to help you analyze the imprints?
Well, they had taken pictures from my report. I can see that there was a compact disc of pictures that they had taken of tires that were on a vehicle, I believe. And there's photos and five printed photos from the scene. They also printed out 5 pictures from pictures that were on the CD. And then there were a number of shoes that they submitted. There was 1, 2, 3, 4.
Let's go through them one by one. So is it the case that you have lab numbers and there's also numbers provided from the crime scene unit on your report here?
There are, yeah, there are, yes.
So we'll start with item 52, which would be CSU item 2, one tire cast imprint. What, and I guess it's the same thing for, so we'll go to item 53, which is CSU item 3, the other tire imprint. What were you able to determine?
Well, as it related to both of those imprints, my items 52 and 53, I determined that the pictures on the CD of tires, I couldn't make a determination one way or another. I couldn't eliminate those tires as having made those imprints, but I couldn't identify them either. Class characteristics are something we look at first. We'll see if the same pattern, basic pattern is there. So the same basic pattern was there, but in tires, it's very difficult to identify a tire specifically to a tire imprint because tires will wear and they develop, they don't develop very good unique characteristics for us to look at. So in looking at those imprints, and a round tire is very, if you were to roll out that imprint, it would be about 6 feet long if you rolled it all the way out flat. So just capturing one small imprint that was made, you don't know where on that tire it may have been made. So it could have been at the top or bottom or whatever. So my conclusions were that it was basically inconclusive. I couldn't say whether the tires, the pictures of the tires that were submitted, that those tires made those imprints, but I couldn't eliminate them as well.
And was, because we've heard about a number of cars, does it list what specific type of car this is on your report?
It says they were off of a Mazda 3.
Moving on to the shoe imprints. For 54, your number 54, which would be CSU 6, were you able to determine anything about that item?
Again, item 54, it says on my report here that there was an inconclusive comparison again to shoes contained in item 62. So I couldn't identify or eliminate item 62 shoes as having made that imprint. The same basic pattern existed, but there was a lack of individual characteristics present in the imprint for me to make an identification. Shoes were eliminated, it appears.
In item 62, is that CSU 133?
It is.
Okay. What about your item 55, which is CSU 9, the other shoe imprint cast?
It appears that that particular imprint that, let me make sure I get this right here. Okay, so I couldn't identify the two imprints as being made by the same shoe. And then I couldn't on item 55, it was not made by any of the pairs of shoes that were submitted. So it was a different pattern present in that imprint that did not match any of the shoes submitted.
Okay. So to summarize, the tires could not be identified or eliminated. One shoe, same, not identified or eliminated. The other shoe print eliminated.
Eliminated, okay. Yes.
I have no further questions. Thank you.
Thank you, Judge. Mr. Doyle, good afternoon. I just want to be clear that you could not positively identify the tire tracks at the scene as being from the blue Mazda 3, correct?
That's correct.
And you could not positively identify or match any of the shoes that were given to you to the shoe prints at the scene. Is that correct?
There was one pair of shoes that I couldn't eliminate. The others I eliminated.
Anything else? All right. Thanks for being here. You're free to go.
Thank you.
Who would the Commonwealth like to call next?
Taylor.
Thank you. Mr. Taylor, you can come right up here to the witness stand. Would you raise your right hand, please? Do you swear to tell the truth and the whole truth? Thank you. You can have a seat.
Could you introduce yourself to the jury? And sir, if you lean closer to the microphone and speak louder, we need to be able to hear you.
Corey Taylor.
Mr. Taylor, how are you connected to this case?
You need to answer the question. Sir, you need to answer the question.
Sir, did you know Larry and Maurice?
Yes, ma'am.
How did you know them?
This is my friend.
They were your friends? Did you know or do you know Anwan Carter? And I know that you're nodding, but we have to be able to hear you. So if you could say yes or no as appropriate. Did you know Anwan?
Yes, ma'am.
How did you know him?
He's my cousin.
He's your cousin?
Yes, ma'am.
Is that on your mom's side or dad's side?
Mom's side.
Did you know Brice Rhodes?
You must answer the question. You all want to approach? Come on up here, sir. We're going to take a short break. Need about 10 minutes. If you all could come back at 1:30, please.
Advice for the jury.
So our, I thought maybe they were just going to have the jury go out while they had a discussion. I wonder.
Mr. Taylor, you can have a seat in the witness chair.
Okay, here we go.
Judge, I'm not trying to overstep. I wasn't sure if he had counsel and if we needed anything like that.
I mean, I'm just going to talk to him about how he has to answer. I understand that, but we still have to have some kind of an answer. It can be yes, no, I don't know, I don't remember, but you can't sit there and not answer the question. Do you understand? Mr. Taylor, I'm speaking to you. Please look at me. Do you understand?
Yes, ma'am.
Okay. Can you all approach, please?
So the big question is, does he get cited with contempt of court if he doesn't answer when directed to do so? Because he's been subpoenaed. I assume that he's a friend or family of Brice Rhodes, since he doesn't want to testify. I'd be tempted to go to resume the video which we were watching at the tail end of lunch, but there may be some discussion that we have in on the record here. So, let's check the docket really quick. Let's see. There wasn't any word on when Corey Richens' next hearing was. She was supposed to have a motion or some arguments supposed to be submitted last week, but don't remember him saying anything about a date, and it looks like there is nothing for Corey Richens in the next 30 days. James Brenner has his preliminary hearing in May, and I don't expect him to be in court before then, but it doesn't hurt to double check. Nope, nothing there. And Jared Lysick is scheduled for a preliminary hearing on the 29th down in Manti. And I plan to go down for that. Let's just make sure that's not been rescheduled. It's still on. Aowen is being a bit frisky here. So I don't think I've seen a trial where we've had a defendant who has been unwilling to testify.
This is the jury's not in here, and I can talk to you about this. So the attorney that had previously represented you no longer is with the public defender's office, but they're gonna send an attorney over for you just in case you need somebody to talk to while you're here, okay?
Sounds like this is going to be a longer break. They're gonna, if he wants to talk to a lawyer before testifying.
All right, whenever the jurors are back, we can get started again.
Wonder if he's an unindicted conspirator. That would be a good reason for him not to want to say anything. Oh, kitty.
Don't get the pictures you needed. Okay, good. Get the pictures you needed, okay. trying to figure out how to get the J cut into here. And I guess what I have to do is switch it over manually when you're using it. But I've been just switching it to overall presentation so the screen would show. Okay.
All 15 jurors are present, Your Honor.
Thank you, Deputy Mills. Ms. Jones-Brown, you can proceed.
Mr. Taylor, how old are you?
25.
Thank you. How old were you in 2016?
17.
So when you were 17 years old, you were friends with Larry, Ordway, and Maurice Gordon, correct?
Yes, ma'am.
And you were cousins with Anwan Carter. You are cousins with him. Were you running around with your cousin Anwan? Did you all four hang out?
Yeah. Yeah.
How did you know Larry and Maurice? How did you meet them?
I met through one of my cousins, Antoine.
You met them through your cousin Antoine? And how is Antoine related to Anwan?
Like brothers.
They're brothers. Okay. Did you all hang out with more people?
No, it was just usually us.
Okay. What sort of stuff would you do?
Females, chill, party, stuff like that.
Where did you go to school?
Went to Lassiter. I went to Butler High School.
Where'd you say?
I went to Lassiter Middle. And I went to Butler High School.
Butler High School. So did you go to school with any of them?
Now my cousin Antoine did. That's how I met him. They went to school together and they came to my granny's house one day.
What neighborhood did you live in back then?
I lived in the South with my cousin.
What do you mean by the South?
South there, like by Olmsted Middle School, our boys' school. You know, in the
Is
South
that where
there.
they all went to school?
Yeah, they all went to school there.
So you would hang out with them after school?
Yeah.
Were you and Anwan friends when you were little kids?
No, not really. I mean, he just my cousin's like blood brother, so I looked at him as like a brother too.
So you were closer to Antoine at first than Anwan, is that what you're saying?
Antoine, me and Antoine grew up together. His mama is my mama's sister. She passed away, Stacy. She passed away, so me and Antoine, we've been tight since I was young.
And was Anwan his little brother? At some point, did anybody in that group introduce you to Brice Rhodes?
Maurice and Larry.
Maurice and Larry did?
Mhm.
About how long did you know Maurice and Larry before they died?
About 4 years.
4 years?
Mm-hmm.
About how long did you know Brice Rhodes?
I don't remember.
Had you known him, would you say weeks, months, or years before the murders?
I don't remember.
Maybe years?
Probably about, it wasn't that long though. It wasn't no year.
Wasn't no year?
No.
And you met him through, I believe you said Maurice and Larry?
Hmm.
What sort of things would you all do with him?
No. Just chill. Really.
Would he take you all out
Time to time.
from time to time? Did he take you all out to eat?
Time to time.
Did he buy you all stuff?
Time to time.
Sure.
How often would you all hang out with him?
I hung with M1 more than anybody, and Maurice and Larry more than anybody. So I can't say how many times we hung together, how often, but it was often. But more than I hung with them two and M1.
Could you, I'm so sorry, but I could not hear all of that. If you could lean closer in.
We hung with them sometimes, but I mean, it was mostly me, Maurice and Larry, and M1. It wasn't, you know.
So it was mostly you four, sometimes him.
Yeah.
How old was he, if you recall?
Who?
Mr. Rhodes.
I don't know.
Was he older
He's
than you?
older
all?
than us.
Did you all ever, well, anytime you hung out with him, were they there, your friends there too? Or did you ever hang out with him, just you and him?
It was mostly just me, him, and Maurice and Larry and Butter. M1.
Okay, and I believe you just said Butta. What is
It's M1.
that's Anwan's nickname? All right,
I'm sorry to interrupt, but let me ask the attorneys to come up. Mr. Faccio, would you mind to come up too? Thanks so much. Sorry for the interruption.
I ain't got nothing to say.
Okay, Mr. Taylor, I want to turn to the May 4th.
I ain't got nothing to say.
Sir, leading up to May 4th of 2016, can you tell us what happened?
I ain't got nothing to say. I respect what y'all doing here, but I ain't got nothing to say about the incident.
Well, that's not true, right? You don't want to. Right? But you do have something to say. Can you please tell the jury about the May 4th incident? Can you tell the jury what happened the night Christopher Jones was shot on 41st Street? Sorry, I know it's hard. Mr. Taylor, were you on 41st Street the night Christopher Jones was shot?
I ain't got nothing to say.
On May 4th, 2016, were you in a car on 41st Street?
I ain't got nothing to say.
Sir, do you understand this is a court
Yes, ma'am.
and that witnesses get sworn in, that they answer questions? You understand that, correct?
Yes, ma'am. I ain't
You
got nothing-
understand that you have information that the jury needs about this case, right? Do you understand that? Do you want me to ask it in smaller questions? Does that help better? Mr. Taylor, were you with those people that you have just talked about? Maurice, Larry, Anwar, and Brice Rhodes on May 4th, 2016? Answer that question. Were you with them that night? May 3rd into May 4th, 2016. So there are 3 answers you can give to that question. You could say, yes, I was with them. No, I wasn't with them, or I don't remember. What is your answer to that question? Mr. Taylor, do you remember a conversation that you had with Detective Tonelli about this incident? And we're going to need you to say an answer. It could be yes, no, or I don't remember. Yep.
Ladies and gentlemen, I need to speak with this witness outside of your presence. Ask you to come back again, and we'll just say 2 o'clock. Take 15 minutes.
All rise for the jury.
Yes, Bella. I'm not sure if she's told him anything while they've had the camera mute. I mean, not the camera, but the mic muted. I think they're probably saving that for a last resort. The fact that he's reluctant to say anything to me means that the jury is probably going to place greater weight if he says anything which goes against Brice Rhodes' interests. So, I still want to know what the story is on that Band-Aid on the back of his head. I went back and found a...
John, can we lock the courtroom door for a moment? Does anybody want to leave for a minute? I'm going to lock the door for a moment.
Locking the door, huh?
Thank you. All right, Mr. Taylor, I'm going to give you some time to talk to Mr. Ferraccio, who is here at my request as your attorney.
Oh.
But let me say this. When a question is asked of you, you can answer it yes, no, or I don't remember. And if you want to, you can explain more beyond that. But simply not answering will result in me holding you in contempt of court and putting you in jail likely. Additionally, it could open you up to other consequences, such as your prior plea deal being taken away and all of the charges against you being reinstated. Now, I do not care how you answer, but you will either answer or remain in the jail. Mr. Ferraccio, I'll give you some time to speak with him now.
He's not in custody.
Yeah, he's not in custody. Yep. Conference room.
So he is another conspirator in this.
Yeah, John, I'm sorry. The outer door is is the one we'll need to secure.
At this stage, yes, everything is something we should have heard. Now they're going to talk to in a conference room because that's going to be with the lawyer they brought in for him personally, and so that's going to be a privileged communication. So this will be interesting. We could have the first time I've watched one of these trials where a witness is held in contempt. I haven't encountered that.
Okay, I'll let him say that. In the context of were you with him, I feel like that would.
This is probably going to take a few minutes.
No, me either, because this is not how it was 5 seconds before this started.
So while we are waiting, I was just looking to see what is in the news. It sounds like everyone is weighing in too.
Lynn Lonnie, you want to come out here with us for a minute, Brian?
Just looking to see what is in the news.
It should be locked.
Oh, here's something. Says a woman was sentenced to at least 70 years in prison for causing the death of two bicyclists who were hit while taking part in a charity ride in western Michigan. What were we coming back in, or just more movement in the court? Nope. Okay, the judge in Ionia County stacked two 35-year terms for Mandy Ben, a rare consecutive punishment. Most sentences in Michigan run concurrently. Police said, well, one point there, what kind of punishment is it for the second victim if they don't do 1 day more time than if it was just for one victim? That doesn't seem like justice for me. Police said Ben was under the influence of drugs when she crossed the center line and hit a group of bicycles on a rural road in 2022. Edward Erickson, 48, of Ann Arbor, and Michael Salhaney, 57, of Bloomfield Hills, were killed while riding in a 3-day endurance event for the Make-A-Wish Foundation. This is not an accident. There was a series of choices made at some point to ingest this cocktail of narcotics that led to everything we saw, Judge Ronald Schaefer said Tuesday. In October, Ben, 44, was convicted of second-degree murder and a raft of other charges. She apologized to the court on Tuesday and read out the names of the dead and injured bicyclists. I know you haven't seen much of it, but I am very, very much so sorry, Ben said. I never in my life had any intention of hurting anyone. That moment changed the outcome of a lot of futures. Well, a couple of people didn't have any future. I kind of don't have much sympathy for her. And she had to know that the possibility of getting in an accident while impaired existed. So she made a decision by getting in behind the wheel. I mean, if she wants to ride a bicycle, say, and bicycle impaired, go for it.
You Tyler Childers fan, Brian?
Oh,
Do you know who Tyler Childers is? Are you Tyler Childers fans? Are you a Tyler Childers fan? Okay, cool. Not then.
Green fan?
Interesting. There's it seems to be a kind of an ad. Oh, where did it go? It says that Utah has made a law that would clear criminal history on it says up to 450,000 Utahns. Yeah, I can't find it. Seem mainly to be an advertisement. Oh, here we go. Yeah, it's sponsored. Let's take a look at that again. March 29th.
Okay, if you're looking for a gift for a friend who is obsessed with new and unique fashion, here is your go-to gift. These are no
2019 lawmakers unanimously passed Utah's Clean Slate Law, which automatically clears more than 450,000 criminal records. However, there is no requirement to notify Utahns whether their record has been cleared under the law. So this sponsored thing is saying you can pay $15 to them and they'll tell you what your record is, but I think you can do that with any background site. That's probably for misdemeanors. Well, he's back on the stand. So I expect I should be bringing the jury back in. Now, the judge said yesterday that today was going to be a shorter day. They went over by a half an hour yesterday. And so if he refuses to say anymore, let's see, it's 2 p.m. there.
If the jurors are here, we're ready. Oh, there's Mr. Griffiths.
Probably another witness, if the witness is available.
Judge, may the Commonwealth have permission to lead?
Do you want to talk about it, or are you okay with that?
Let's talk about it for a second, Judge.
Come on up. Hang on just a second. Sure. He's going to say all rest of the jury. It's good. They can come on in. Thank you, Deputy Mills. Ms. Jones Brown, you can pick up where you left off.
Okay, Mr. Taylor, returning to 16, were you there when Christopher Jones was killed?
Yes, ma'am.
Where were you? You in a vehicle?
I was in the back seat.
Backseat of the vehicle?
Mhm.
Whose car was it?
Brice.
What color was the car?
Blue Mazda.
Mazda?
Mhm.
Who was driving?
Maurice.
Who was next to Maurice in the front?
Larry.
Who was in the back?
Brice.
Were you behind Maurice or Larry?
I was behind Larry.
And the defendant was behind Maurice?
Mhm.
So driver's side rear?
Yes, ma'am.
Why were you, oh, was Anwan there?
Yes, ma'am.
Where was Anwan?
He was behind us in the truck.
What truck was he in?
He was in the truck he had that day. He's following us.
He followed you?
Yes, ma'am.
Do you know how he got the truck? Was it a truck that he had long term?
Nah, just for short term that day. Just for that day.
He showed up in the truck that day?
Yes, ma'am.
Okay. Why did y'all go to 41st Street?
Looking for somebody.
Who were you looking for?
I don't know.
Did you ever know specifically who you were looking for?
We never knew. We just went along with it.
Who knew? Who was the person who knew?
Brice.
Sorry.
Brice knew.
Did he tell you all who he was looking for?
No.
But did he tell you why he was looking for someone?
Something about a price on their head or something like that.
Somebody with a price on their head. What does that mean?
Somebody with a price on their head, like looking for him.
Does that mean that somebody else is gonna pay if this person gets killed?
It means the person who did it get paid.
Person who did it gets paid? Okay. How did you all know that there was somebody with a price on his head?
Brice told us about it.
Did he tell you all about this before that night or that night?
It was at night.
Did you, okay, so y'all are driving down 41st Street, you're in the back seat, Anwan following, what happens?
Rode around. Maurice rode around. Stopped the car. And he seen somebody in the middle of the street. And Brice told him to get out the street. Shot him.
Who shot him?
Brice.
Brice Rhodes shot him. So you're in the passenger side rear, right?
Mm-hmm.
So were you all, was the person who got shot on the other side of the street from you all?
He was on.
You don't know? It's probably an unclear question. Was the fellow on the sidewalk or in the street?
Street.
Okay. Was he crossing the street or what was he doing?
He may have been crossing the street. He was in the street, but he may have been crossing the street, but he was in the middle of the street.
Did Mr. Rhodes shoot him with a gun? I know that's obvious, but just to be clear, it was with a gun, correct?
Yes, ma'am.
What type of gun was it?
9mm.
How did he get the gun?
Got it from me.
Where did you get the gun?
Friend of mine.
How long have you had the gun?
I didn't have it a day.
You didn't have it a day, so you got it that day.
Yes, ma'am.
Why did you get the gun?
My own protection.
And how did Mr. Rhodes end up with it?
He was with me that night. He's with all of us at night. He told us that somebody had a price on their head, so he wanted the gun. So I gave him the gun.
Could you describe how he shot Mr. Jones?
He pulled up and he was in the street. I just remember that he shot him. I don't really remember. I just know he said, "Get out the street" or something like that. And he shot him.
And were you sitting next to Brice Rhodes when he shot Mr. Jones?
Yes, ma'am.
Did you know Mr. Jones at all?
None of us did.
Had you ever seen him before?
Nah, I ain't never seen him dead in my life.
Did you ever find out if he in fact was the person with the price on his head?
Judge, we would object.
I'll sustain it. You want to approach?
No, I can rephrase. How did you feel about this situation?
I was young. I just went along with it, to be honest with you. We all did, you know what I'm saying? We just
I'm sorry, what was the last thing?
we just went along with it.
Did Mr. Rhodes, to your knowledge, did he ever show up with money from this price on the head business?
No, ma'am.
After the shooting, what did you all do?
We went to Maurice and Larry's house.
Did all 5 of you go or just some of you?
We all went.
Okay. What happened at their house?
We didn't really talk about much. We just basically just told us not to tell nobody. That was it that I remember.
Okay. Did you all discuss it later amongst yourselves?
Not really. I mean, to be honest, we ain't never seen nobody like get shot, you know what I mean? So I'm not gonna lie, we was all scared, you know what I mean? It wasn't just them two, we was all scared, you know what I'm saying? Maurice, Larry, all of us, we was scared, man.
You were scared?
Yeah, we was young, you know what I'm saying? We just went along with it.
Did you all, any of you, discuss this prior to May 21st?
Yeah, me and Maurice did. And Larry. He told me he wasn't messing with Brice anymore because of the situation.
Judge, I can object to this.
Did Brice Rhodes say anything?
No.
Okay. Did he say anything about Larry and Maurice?
Just said that he can't mess with them no more because they told their mom about the situation. He feared they would say something to the police.
So he believed they told their mother?
Yes, ma'am.
What does he mean that you can't mess with them?
No,
What did you, I know you don't know, but what did you understand that to mean?
Judge, we reject the speculation.
I'm gonna sustain that.
Okay. Did he tell you anything that he thought should happen?
He feared they would tell him, so he was saying we can't mess with them no more. Get him back for telling him. That's how I remember.
Get him back for telling?
Yes, ma'am.
Did he say anything more specific?
Not really, not that I remember.
Do you remember talking to Detective Tonelli about this?
Yes, ma'am.
Do you think if you saw a transcript of your conversation that might help refresh your memory?
Yes, ma'am.
May.
I'm gonna show you these. Specifically.
Yes, ma'am.
Does that help refresh your memory? What did he tell you he wanted to do to them?
So we gotta kill him.
At that time, did you believe him?
Shocked. I mean, I didn't know what to believe, to be honest, because of the Chris situation. I didn't really know. I just I don't really know.
Where were you when he said this?
As I remember, it was just he was in the car one day. I don't remember what day. I don't remember what day. I just know he was in the car and he was telling me this. Because Maurice was scared, you know what I'm saying? Like he was scared that he was gonna tell or whatever. So he was telling me that.
Judge, it's difficult for me to hear the answer, but I believe it's a mix of hearsay and non-hearsay. Check the hearsay part.
Sustain.
Let's move on to, well, in this time period, were there days when you saw Maurice and Larry?
Yeah, we was still with him every day after that.
Okay.
Me and Anwan was.
Were there days that you saw Brice Rhodes?
Yeah, at times, not often.
Okay. Tell us about May 21st, which I believe would have been that Saturday.
I remember riding around with my cousin Q. Me and Anwan was riding around with Q that day.
So Q is the nickname of your another cousin?
That's my cousin.
So Q and Anwan and you were in a car?
Yes, ma'am.
What were you all doing?
Just riding around, females. Q had a girlfriend. We were just riding around. I was calling Maurice and he was calling Larry because we was trying to go back to their house that day. And, kept calling and stuff like that because we usually we'll go out, we'll be out that day, and like at the time I really didn't have nowhere to go. You know what I'm saying? So
Where were you living then?
house to house.
House to house?
Different friends' house.
What was going on with your? Did you typically live with your mom or your dad?
I had issues with my family.
Okay. So did you, how long had it, well, when you were really little, did you live with your mom or your dad or both?
My mom, for the most part. My dad got killed.
At that time, were you living with your mom?
Yeah, I was living with my mom off and on. That's the reason why I was bouncing from house to house, because I didn't know where to stay at the time.
Okay. Okay, so you had a cousin Q who was driving you around that day with Anwan. Was he also Anwan's cousin or was it the other side of the family?
Q didn't really look at him as a cousin, but you could say that because Antoine, which is Anwan's brother, is Q's cousin too. That's my mom's sister.
Okay.
So we was all cousins anyway.
So you Anwan and Antoine have different moms or dads?
They got different moms, same dad.
Okay. So Antoine was your all's cousin and he was Anwan's brother. So you are related to Anwan through that? Okay, got it. So you're riding around with Q. What happens?
Calling, I was calling Reese, calling him back to back, trying to see, we was trying to go over there that night. Something, as I remember, I said that, Maurice actually, he called me and let me know he was, I forget, at the time, no, I'm sorry about that, rephrase that. I called him to go over there, and when we finally went over there, they was gone. Me and Butter went over, they was gone. And
so you went to the house where they lived with their mom?
Yes, ma'am.
Over by Airplay Park?
Yes, ma'am.
And they were not there? Okay.
I was confused because he told me after Maurice telling me that he wasn't hanging with him no more, fooling with Brice no more. I was confused on why he was still with him and why they were still, with Brice after the situation with Chris. So I went there to spend the night. Me and Butter did, and we got there. Their cousin answered the door, and they wasn't there. They wasn't there that night. When we left, we kept calling Maurice's cell phone. I called Brice's cell phone. I was like, "Where Maurice and Larry at?" And said that they right here and stuff like that. And Maurice is in the background and Larry's in the background partying. There's people over there. I just thought everything was fine at that point. I didn't really think nothing like back when you asked me like was he serious? You know what I'm saying? Like about doing that to them. I mean, at that point I didn't think he was serious no more. You know what I'm saying? Like I didn't really think nothing of it. I thought he was just gonna let him live. We was all gonna be cool. Stuff like that. I didn't really think he really gonna do that. I thought we was gonna party, so I insisted on going anyway. Even though Q and N1 told me not to go, I insisted because I ain't had nowhere to go. Q and N1 really could have went to their family. Me, I just wanted somewhere to stay at night. I ain't really thinking about hurting nobody or nothing like that. We wasn't thinking like that. N1 didn't want to go. My cousin didn't want me to go, but I insisted on going anyway.
So you went to get someplace to stay?
Yes, ma'am. So we went to Brice's apartment that night. My cousin Q dropped me off. He dropped me and N1 off.
Why didn't Q go?
Q didn't want me to go anyway. Q didn't really fool. He didn't really fool too much with Brice anyway. He didn't want me around him, so that's why he didn't really want me to go. We went that day. As I remember, it was people in the house. I believe a female and two guys, a female and a guy, as I remember. So and they was drinking. Everything was cool at that point. You know what I'm saying? Everybody was just in the house, chilling. I remember two other people being there, and I'd never seen them before. Me, N1. Never seen them before.
Were Maurice and Larry there when you got there?
Yes, ma'am.
Okay. So it was Maurice, tell me if I get this right, Maurice, Larry, Brice Rhodes, a female, and two dudes you'd never seen before? Okay. And so at first everything's cool?
Yes, ma'am.
Okay. How long did everything stay cool?
Everything was cool until we was all drinking and we was all just there, and I didn't know the other two people that was there, the two juniors there. So I'm really confused at that point. I didn't really we just partying, we kicking it, and then I remember that Brice said he asked Maurice, "Are you telling on me?" or something like that. Are you telling on me? Are you telling on me? Or something like that. Something like that. I just remember that part or something like that. He was asking questions and stuff like that. And Maurice had said something to me, and we was kind of arguing. We got into a dispute. And as I remember, that was before Brice had asked him, "Are you telling on me?" It had nothing to do about, the situation. Me and Maurice just got into a dispute over the fact, like, we was all drinking, we was partying and stuff like that, and stuff kind of, you know what I'm saying? So, he asked him, like, "Are you telling on me?" And he kind of denied it, like, "Nah, I ain't doing that," stuff like that. At that point, he said we gotta violate him and stuff like that. I didn't understand. He just wanted, like, he just said violate him. And then, as I remember, before that, I just remember Maurice picked up a knife on me or whatever, and Brice had grabbed the knife from Maurice, and that's when he hit him. You know what I'm saying? He hit him.
So he hit who?
He hit Maurice.
And who is the one doing the hitting?
He hit Maurice because picked up a knife on me.
But I'm sorry, just to be clear, who hit Maurice?
Brice.
Was the female still present at this point?
Female? Now everybody left. The female left because it was too many dudes there. As I recall, like it was too many dudes at that point, so she left, and the other two people stayed. And Butter was there, and Maurice and Larry was there. But after that, he kind of like he didn't really go at me with the knife. He did, but he didn't. It was aggressive, so he hit him. Brice hit Maurice and made him put the knife. He grabbed the knife from him, and that's when he insisted on doing what he did.
Okay, so everything's cool. You and just tell me if I'm getting this timeline right. You and Maurice kind of get into a little argument.
Yes, ma'am.
I mean, did you think it was a serious argument?
We've been into it before, and next day we right back. Right back good. So I didn't think nothing of it. We didn't think to do it in that. No, it don't matter.
Okay.
To make it that serious to even, you know what I'm saying?
So when he pulled the knife, were you scared?
At that point, we all confused. You know what I'm saying?
No, I meant when Maurice pulled the knife.
I just kind of, I remember lunging, like,
Pardon?
I remember jumping back, like lunging back, like, you know what I'm saying?
And so at that point, Maurice pulls the knife. Mr. Rhodes takes the knife.
Yes, ma'am.
And when you said he hit him, was it a slap or a punch? Or what? Describe it however you remember it.
I don't remember. I know it was either slap or a punch. I just know he hit him, and he took the knife from him.
Where were you all in the apartment?
He was in the living room.
And was everybody standing, sitting?
We was standing at that point. Everybody was standing around.
Okay, so after the punch or hit, I'll say hit, is all this happening before or after he started talking about the violating?
I just know that he said we gotta violate him or something, violate them or violate him.
And is that after he hit him?
After he hit him, because
I'm just trying to get the timing. I'm sorry.
Yes.
Okay, so he says, so is that like disciplining?
Yes, violate whatever he was planning on doing. Violate somebody.
When he said that, what happened next?
He said something about, he told me to Brice had told me to he said I want you to violate him. I was scared, so I'm like, what you mean? He said it. He's like, I want you to punch him in his chest. And if you hit him in his face, I'm gonna hit you. He told me it's Maurice. I just remember he had me punching him. He said stop. Or something like that. And he had I thought everything was fine at that point until he said we gotta tie him up. We gotta tie him up or something like that. As I remember. You know, it's been a while, so I just remember certain detail like that. You know what I'm saying? That I can remember. But I just remember that he said we gotta tie him up and tied him up and pinned him down. He stabbed Maurice and
Who stabbed Maurice?
Brice did.
Okay. Was Maurice tied up at that point?
Yeah, he was tied up.
What was used to tie him up?
I don't really remember. I just remember that he was tied up.
Okay. Who did the tying?
Brice did. And somebody else that was there. I don't really remember. I just know he was tied up and he had a sock in his mouth and he pinned him down and he began stabbing. He made anyone stab him too.
Where did you see where he was stabbing him?
Man, stomach, chest, stuff like that.
Do you know how many approximate times it was?
It was a lot. I don't really remember.
What was Maurice doing while this was going on?
What can you do?
Who was in the room while this was happening?
Yeah, it was me, brother, Brice, two other people, and Maurice. He's pretty much fighting, fighting, trying to, he made N1 stab him, and once N1 stabbed him, he kind of moved him to the door. He just had me standing there.
You were standing by the door?
He, two other people that was in there, I didn't really know. They was already there when we got there, so I'm thinking that, you know what I'm saying? In my mind, I couldn't do nothing but stand there, worrying if somebody's gonna do something to us for, trying to interrupt anything. So he went to he kind of took Maurice to the door. They all, well, I don't really remember who, but I just remember he going to the door. And Larry was in the bathroom. He made Larry come out, and the same thing happened to Larry. And once he did Larry, he made me stab Larry.
So I'm sorry to make you talk through this again, but I want to just get the picture of where everybody is. While Maurice was being stabbed, where was Larry?
He's in the bathroom.
How did Larry get to the bathroom?
The other two people put him in there.
Did Larry want to go to the bathroom?
They made him.
Could you hear Larry in the bathroom?
I don't really remember. I just know he was in the bathroom until Maurice was pulled out the living room.
After you said Brice Rhodes stabbed Maurice a lot of times, and then he made Anwan stab him.
Yes, ma'am.
Had Maurice stopped moving at that point?
I don't really remember, ma'am. I just know that he pulled him to the side and made Larry come out next.
How did he pull him to the side?
Put him by the door.
Was Maurice walking, or was he down on the ground?
He was down.
And did he drag him to the door or carry him to the door? You know?
I just remember he was can I grab a tissue? I just remember he grabbed him to the door. He slid him to the door. I don't know, man. Then Larry came out. I just know he had somebody watching the door to make sure wasn't nobody coming in the house.
When Larry came out, could he were his eye, I mean, could he see what happened to his brother, or were his eyes covered?
Not that I remember.
You can't remember? Okay. So let's walk through what happened to Larry. I'm sorry, but how did it start? Was he tied up?
Same thing. I just remember that. I remember him trying to break free, and he pinned him down and began stabbing him. And then after he was down, he had me the knife and made me stab him as well.
How many times did Brice Rhodes stab Larry?
I don't recall, I don't really remember. I just know that he stabbed him.
To your knowledge, was Larry, did he appear alive when you were stabbing him?
No, ma'am.
How many times did you stab him?
Just once or twice. After the fact that
Did Brice Rhodes say anything about why he stabbed Larry?
I mean, not really. I just know once we was in It was in it. There was no, we involved pretty much. We there. We just, so we just as guilty. We there. Couldn't do nothing though. I mean, I was scared. I was scared. I don't know. I just know. Couldn't really say.
Did the other two guys participate in the stabbing in any way other than restraint?
Yeah, after the fact they was already down, he made them stab him as well.
Did you know these two guys at all?
Never seen him. Only part. Me and Emma never seen him. I believe Maurice and Larry knew the other two guys, but we didn't know him.
Were you later able to give a description of either of them to Detective Sinelli?
So brown skin or light skin or something like that. Well, as I can remember.
So you described one of them as light skinned and one of them as darker skinned?
He was light skinned.
Okay.
Brown skin, light skin.
Did you have anything else to go on? After Larry was down, what happened to his body?
The same thing. He moved him to the side of the door. He made us put him in like laundry totes or something like that.
Laundry totes? When they were, to back up 1 second, when they were in the living room, were they just on the carpet or was there anything down on the carpet? When they were kneeling down, if you recall, was it just they were on the carpet or was there a blanket down or anything, sheets, anything?
I don't really recall.
Okay.
I don't remember.
So you all put them in laundry totes?
Yes, ma'am.
Are we talking like laundry hampers, like you would carry your
Yes, ma'am.
laundry down the steps in?
Yes, ma'am.
Okay. All right, they're in laundry totes. Now what happens?
He made, I just remember, he made all of us carry him to the car.
And which car was that?
The blue Mazda.
Did you all put them in the Mazda?
Yes, ma'am.
Where did the bodies go? Oh, like what part of the car?
It was either the back seat or it was the trunk. I don't really remember. I just know that he took the blue Mazda.
Okay. Did you all get in the car after that?
No, me and Anwar actually stayed back. He told us don't go nowhere. He made us clean up.
How did you clean up?
I just told Anwar, we gotta get out of here. And we gotta use bleach. We gotta use bleach to get this up. We just cleaned it. We cleaned it up with bleach.
What happened next?
Cleaned up until he got back.
He got back?
Yes, ma'am.
By he, who are we talking about?
Brice.
And did he come back alone?
Yes, ma'am.
Did he tell you what happened to the bodies?
Said that someone said it was burnt.
He said he burnt them? Well, did he say who burned them?
No, ma'am, he just said he dumped them in the backyard.
And he told you the bodies were burnt?
Yes, ma'am.
Did he tell you where he dumped them?
West End somewhere.
West End?
Yes, ma'am.
Was he satisfied with your all's cleaning job?
I don't know.
Did you all clean more when he got back?
He was just trying to dispose of all the evidence, pretty much.
So what happened with that?
He made everyone clean the blood. When he got back, he was disposing of evidence. So
What type of evidence?
could have been clothes. It could have been, you said sheets. I don't really recall. I just know it was evidence.
And was it stuff with blood on it?
Yes, ma'am.
What did you all do with that stuff?
It was took to a dumpster and they burnt the stuff up.
Okay. Why didn't you and Anwan just leave during the night?
You said, why didn't we?
Why didn't you? While he was gone.
I was too scared, to be honest with you. I wasn't even in my right state of mind at that point. I mean, me personally, I never witnessed or seen nothing like that in my life. So, man, I don't know why we didn't leave, man. To be honest, I just know we was scared. We just went along. We just did what he told us to do.
So when he got back, and you all dealt with the evidence, what happened next?
I just remember riding around and getting dropped off, as far as I remember.
Where'd you get dropped off?
I know we went to a few spots, but I don't really remember the spots we went to. I just know we took us somewhere. I went home, and then he got dropped off somewhere. So, after that point, I went to my grandmother's house, and that was it.
Did you eventually, did you have a pair of black Timberlands?
Yeah,
Tell us about those.
Those was originally mine. Those was my boots that I got. I just I let Maurice have them at that time. I don't know if I had them on that day or the situation. I don't know if I had them on that day. I just know they had blood on them. And then everything that I had on, I just was trying to get rid of. Stuff like that. The only thing I had was the boots on. I just remember putting them in a closet at my girlfriend's cousin's house. And I put them in a closet. And I kept them there until I was picked up by police.
Was that Monisha Anderson? Monisha, was that her name? Your girlfriend's cousin?
Yeah, Monisha Anderson.
And was that on Liberty Bell?
Yes, ma'am.
And after, were you arrested on this 3 days after it occurred?
I was arrested on May 25th after the 22nd. So, I was arrested. And I knew they was coming for me, obviously. They already arrested Brice and Anwan, so I knew they was coming for me.
And that day, did you talk to Detective Tonelli?
Yes, ma'am.
Did you tell him what you just told the jury on May 25th?
Around that time, everything, my first statement, I didn't.
What sort of statement did you give at that time?
I just told him that I didn't know.
Why did you say that?
Scared. I didn't know. I just didn't want to say what was going on at that time. I be honest, I really didn't want, I didn't know what to say, man. I didn't know. I just didn't tell him everything. I just remember saying certain things. I didn't really tell him everything that was going on in the situation.
Later on, did you give a different statement?
Yes, ma'am, I did.
And what had changed at that point?
Everything I just said, pretty much, in the first one. Everything I just said.
Is this the true statement?
Yes, ma'am.
At some point, did you receive some correspondence from Brice Rhodes? A letter?
Yes, ma'am.
I'm gonna show you, I'm just gonna go through these page by page before we talk about them with the jury, just to make sure that we have, you know what I'm talking about. Do you recognize this page? Did Brice Rhodes give this to you? Okay. And what about this page? Did Brice Rhodes give this to you?
Yes, ma'am.
Did he give this to you?
Yes, ma'am.
And then the fourth page?
Yes, ma'am.
And did he give these four to you at the same time or different times?
It was the same time.
Did you see him as he gave these to you? Like you physically got these from him?
No, I didn't physically get it from somebody gave them to me.
Okay, did you see that all take place?
Yes, ma'am.
Okay. Your Honor, the Commonwealth moves to admit these.
Judge, we would object and move and ask to approve.
Sure.
They've not mentioned any gangs. According to one of the witnesses, he said that he was going to, that it was a contract kill. And I guess he promised the other guys some money if they participated. Of course, they didn't get any money. And but they did get some Sharon penalty. The defendant was an aspiring rapper, and I found a video of that he did, and I don't think I'll play it. I mean, I don't think I'll play the audio because, don't want a copyright strike. I think that YouTube does things sometimes automatically. I don't know. That I don't want to take the chance. And it's also probably laden with profanity, but we can at least see him in all his glory. And hope you can sense the irony in my voice. He's not wearing a shirt so he can show off his tats, and he doesn't have that great a bod. I mean, sorry. So anyway, yeah, this guy is the cousin of somebody else who testified, or, well, he was one of the, I saw a clip of the one in jail. I'm having trouble remembering the name of the one that testified yesterday, that their cross-examination was kind of dicey because it was pointing out lies that he had told. How serious that is, I'm not really sure, because some of the lies seem like there's something that anybody involved in a crime is going to do. They're going to tell, no, I don't know him. No, I wasn't there. No, I didn't see anything. Because that's standard operating behavior for most of these guys. So, not 100% sure on that. Oh. So, yeah, he doesn't want to be there. And in the last break, the judge told him that if he didn't answer the questions, that he'd go back to jail. Now, they pointed out he isn't in jail, but he could go to jail on contempt, and his plea deal might be revoked. So, yeah, I feel sorry. These guys were all really young, and this guy was several years older, or at least, well, let's see, how old is he now? This was took place in 2016 in May. Yeah, he was 25 at the time of the crime, and these guys were all teenagers. 17, one of the victims that was murdered was 14. I think the other one was 16. And that's because they were witnesses to the shooting, which was the supposed contract kill. I don't know that it was a contract kill. I think that he was probably trying to impress them with, him being bad and, gangster type. But I haven't heard anything yet that there was anything behind that. So, and in the write-ups, I haven't seen any mention of a contract hit, and we don't have a person who hired him to do it. So I think he was just trying to impress these young teenage kids who thought he was cool because he was a rapper, and yeah, I'm sorry, not impressed. Probably. Now they said that in October the judge ruled that he wouldn't face the death penalty.
Mr. Taylor, did you recognize this as Brice Rhodes' handwriting?
I mean, I know it's passing. I don't know if he writes like that or not. That's what you asking. I don't know if he writes like it or not.
Sir, was any of this, was killing Christopher Jones your idea?
That was none of our idea. It was brought to us.
It was brought to you? Whose idea was it?
Brice's idea.
Who shot Christopher Jones?
Brice.
Was killing Larry and Maurice your idea?
Oh, man.
Whose idea was it?
Brice.
Who began the stabbing of Maurice Gordon?
Brice.
Who began the stabbing of Larry Ordway?
Brice.
Who told you to stab Larry Ordway?
Brice.
I have no further questions.
Thank you, Ms. Jones Brown. Somebody need a break? Yeah, all right, let's take a 5-minute break. Back outside the doors. Well, let's just say 3:05.
All rise for the jury.
So he participated in the stabbing. Now, you'd notice there's a little window to the left of the judge here, and yesterday there was a guy who was photobombing through their little window. It was pretty funny. So I'm not sure if this is just a bathroom break or.
Okay.
That's a really good point, not because I think they said it was in West Louisville, and I stopped for gas in Louisville.
Oh, sure. I'm gonna turn the white noise on.
There was a place with a good gas price, and so we got off the freeway and it was not the worst I've seen, not like East St. Louis, but it was not impressive. And real economically depressed neighborhood. I don't know. Hopefully he can get away. I mean, he seems like he doesn't strike me as being completely irredeemable. I think that if he changes who he associates with and so forth, that he could turn his life around. Mr. Tattoos and stroking his beard and mouthing off and threatening the judge and the judge's family and his lawyers. He keeps saying, someday I'm going to get out. Well, I don't think so. And the fact that he's been making threats to a previous judge and to previous lawyers and so forth, that it's not going to make it very likely that if convicted that they are going to make him eligible for parole anytime soon. I mean, the max sentence is life in prison without parole. He was facing the death penalty, but the judge ruled that he had some intellectual disabilities and had suffered from mental health issues a lot of his life. So chances are, with them arguing mitigation, that it wouldn't have been, I mean, he wouldn't have been sentenced to that anyway, but you kind of wish that the worst criminals would face the ultimate penalty a little more often. Not that they ever get executed, they just sit on death row, but it serves as a deterrent to other people when it comes to avoiding trial. Most cases that I've followed closely in the last 20 years here in Utah, the person takes a plea for life without parole in order to avoid the death penalty. So yeah, it's if anybody watched the footage, they'd see that he clearly did not want to testify, but that's not going to carry much weight with a bunch of thuggish types. And probably the best thing that could happen to him would be for him to move to a different city where nobody knows him and start his life fresh. I mean, I don't know what his plea deal was. If I think one person had a plea deal that they had 20 years of supervised probation. I don't know if it was this guy. I just remember hearing that. So yeah. The one that was on the stand yesterday, he was so young. I think he was like maybe 15 at the time of the crime. And, completely mess up your life because you're following some idiot. So, okay, well, let's go back to look and see what is happening in YouTube land. Let's see. Okay, we had that case in Idaho I think it was last week, where the guy killed his pregnant wife and 10-month-old son. And let me pull up the article, which just posted on East Idaho News, probably Nate Eaton. Jeremy Best placed on conservatorship. Court hearing canceled until court determines mental competency. That's fully what I was expecting. Says a man charged with the murder of his wife and unborn child will no longer appear in court Monday. He's also been placed on a conservatorship. Jeremy Albert Best, 48, is charged with 2 felony counts of first-degree murder in connection with the deaths of his wife, Kaylee Randall, and her unborn child. The police say Best also kidnapped his and Kaylee's baby, Zeke Best. 10-month-old Zeke also later died, and his cause of death has not been released pending the results of an autopsy. More charges are likely once those results have been returned. According to the release from Teton County Prosecutor Bailey Smith, Best's preliminary hearing has been vacated by order of the court, and proceedings in this case are suspended until capacity determination is made pursuant to Idaho Code 18-210. Smith tells East Idaho News that the mental health competency evaluation ordered for Best by the court has not yet been completed, so the hearing had to be vacated. Let's see. The code says all persons are capable of committing crimes except those belonging to the following classes: persons who committed the act or made the omission charged under the ignorance or mistake of the fact which disproves any criminal intent. So much for the ignorance is no excuse in the sight of the law. Person who committed act charged without being conscious thereof. So it's basically the same thing as the first one. Persons who committed the act or made the omission charged through misfortune or by accident when it appears that there was not evil design, intention, or culpable negligence. Okay, that one works. Okay, and the last one is the one that applies, I think. Persons, unless the crime is punishable with death, who committed the act or made the omission charge under threats or menaces sufficient to show that they had reasonable cause and did believe their lives would be endangered if they refused. Well, seems to me none of those really fit. Newly filed documents also state that Best's examination has not been completed, citing extraordinary circumstances pursuant to Rule 5.1 of the Idaho Criminal Rules. Rule 5.1 states that every defendant charged in a complaint with a any felony is entitled to a preliminary hearing unless indicted by a grand jury. On Wednesday, documents were filed showing a woman named Patricia Best petition to have Jeremy placed on a conservatorship due to him having been incapacitated. Nope, here we go. Yes, it's a very sad case. If you look at that earlier in the day before the murders, he was in a store completely starkers.
So I'm gonna ask if you can so everybody can hear you, okay?
Yes, sir.
We have a lot of things I need to ask you. And I'm gonna ask you about a lot of the same topics that the prosecutor asked, but I have some different questions, okay? If my questions don't make sense, tell me. Okay? And the prosecutor had transcripts because you talked to the police multiple times, right?
Yes, sir.
All right. I got them too. We can start off with some things we can agree with, okay? So you were definitely involved in these deaths, right?
I was present. Yes, sir. I was there.
I really shouldn't call it this. I'm going to call it this. You were involved in all three of these murders, right?
I was present.
You're not. You don't really want to answer that question, right? Right?
If I was there.
That you were involved.
Involved. If I was there. Just as guilty, right?
In fact, you have not wanted to ever be in a courtroom talking about this, right?
No, sir.
You were hoping that you never get caught, right?
Yes, sir.
But you did, right?
Yes, sir.
I want to ask you about another thing that we agree about. The gun. The gun that you admitted when the prosecutor was questioning you, the 9mm, right?
Yes, sir.
You purchased that?
Yes, sir.
You purchased that by yourself?
Yes, sir.
Where'd you buy that?
Out in the home that night that happened.
Tell the jury where that home is.
Maurice and Larry's house.
You purchased that gun at Maurice and Larry's house.
Yes, ma'am. Yes, sir.
You purchased it the night of the first murder.
Yes, sir.
Which room of the house were you in when you made that purchase?
No, I was downstairs.
I really couldn't hear that.
I was downstairs.
Was it in the living room, the kitchen, a bathroom?
Say that.
I'm not trying to be a jerk. I really couldn't understand that.
Downstairs. I don't remember what room. I just know I was downstairs.
So you're saying it was downstairs, you just don't remember which room?
Mm-hmm.
Okay. But you remember buying it. Was it with cash? Did you buy it with cash?
Yes, sir.
Do you remember how much?
Like $200-300.
Where'd you get the money?
I don't remember.
Who'd you buy it from?
A friend of mine.
Who?
A friend of mine that was there.
I understand that. I am asking you who the friend is.
He was kin to Maurice and Larry. He was kin to Maurice and Larry, and I bought the gun from him.
You bought it from someone related to Maurice and Larry. I'm going to ask you again. I'm not trying to be a jerk here, but you really haven't answered my question. Who sold you the gun at Maurice and Larry's house?
He was a friend of theirs. I know he was there that night.
I'm not trying to be a jerk. I actually.
It's a friend of Maurice and Larry's. And I bought the gun from him. He was there that night, and I bought the gun from him.
And folks knew you were there buying that gun.
Yeah, and one did. Maurice and Larry did.
You said that it was the same day as the first murder. I'm not asking you exactly what time, but was it at nighttime?
It was at night.
So it was a few hours later that it was used in a murder.
Yes, sir.
You said to this jury today that you got it for your own personal protection.
Yes, sir.
That's because telling this jury you got that gun for a murder sounds pretty bad, doesn't it? Doesn't sound good, right?
Doesn't sound good, but I didn't get it for that. I didn't purchase the gun for that. I purchased it for me, my own protection.
It wasn't used for your protection, was it?
Nah. I didn't have it long. I didn't have the gun long to even use it.
That's exactly where
For
I
my
was going.
protection.
That's exactly where I was going next. And you got rid of that gun.
No.
Still got it.
Gave it to Brice.
That gun was disposed of that same night, right?
Correct. That's right.
Your cousin, N1, right?
Mm-hmm.
You call him Butter?
Yes, sir.
Am I pronouncing that right?
Yes, sir.
You agree that he was in a truck the night of the first murder?
Yes, sir.
Pickup truck?
Yes, sir.
He was driving?
Yes, sir.
Stolen pickup truck?
Say that. Wasn't his. He was too young to drive.
I know your answer was you can say that.
Yes, it was.
You helped him steal it.
No, sir.
That truck ended up getting burned, didn't it?
Yes, sir.
Where did it get burned?
I don't remember.
You helped burn it.
Not to my knowledge. Not that I remember. Anyway, sorry. Not that I remember. I didn't help burn no truck. Not that I remember.
Your answer to whether or not you set fire to a stolen pickup truck is not that I remember.
I don't remember burning no truck. I didn't burn no truck.
Was it burned here in Jefferson County?
Yes, sir. In Louisville.
You know the county pretty well. Where was it?
In Louisville.
Yeah.
Sure. I don't know where. I don't remember where, but I know it was in Louisville. Yes, sir. It was burnt in Louisville.
About when was it burnt?
Same day or the next day. I know it's after the Chris incident. I know it's burnt after that.
I notice you have face tats.
Yes, sir.
Is it one or two?
It's one. It's a name.
Okay. And I'm not sure. Do you mind angling yourself just a little bit? I'm not trying to jerk. So the jury can see. What is the name there, sir?
My daddy. MDIP Corey. My daddy.
And you also have an additional tattoo that I can see on your neck, right?
Angel Wing. Mm-hmm.
I want to ask you about something else, okay?
Yes, sir.
You talked about today about murders. When you first came in this room, you didn't want to answer those questions, right?
Sir.
It's fair to say that this isn't the first time you have not answered those questions. That may be a bad question that I just asked, so I'm going to ask it differently. Okay. When you spoke to the police, you didn't want to answer any questions about your involvement either, did you?
No, sir.
What you're saying today is that Larry and Maurice are good friends of yours.
Yes, sir.
But you're also admitting to this jury that you were involved in the murder.
Yes, sir. I was there.
A little bit more than there, right?
I was there.
Well, let's talk about some of the differences between just being there and what happened. You're telling this jury that there were a whole bunch of people there, right? More than 5.
Yes, sir.
You told this jury that Maurice actually started something with you.
Yes, sir.
Prosecutor minimized it a little bit, but I want to make sure that I understand what it is that you're saying. You're saying Maurice pulled the knife on you.
Yes, sir.
There are different knives in this world, right?
Yes, sir.
Is the knife that we're talking about a knife that folds? You understand what I'm asking?
Yes, sir. I don't recall what kind of knife it was. I just know it was a knife. I remember it was a knife.
So as opposed to a kitchen knife or something like that, they're different. So you're saying you can't identify, don't know what knife at all?
It wasn't no regular kitchen knife. It was a knife. I just know it was a knife. It wasn't no kitchen knife.
Okay, not a kitchen knife. Did you see, and I'm asking you on your own, see him where he got it? Out of his pocket, someplace else, you know?
Not that I recall. I just know it was a knife there. He kept a knife with him.
So was it his knife?
Was it his knife?
Yes.
Yes, it was his knife.
So
No, you talking about Maurice's knife?
I am.
No, it was his knife. It wasn't his knife. I'm sorry about that.
All right.
He picked up a knife that Brice had, that Brice carried with him to attack me with it. to charge at me with it.
Okay.
Yeah.
So that's the night, and if I'm being confusing, you tell me, all right? That night got pulled on to.
Yes, sir.
Can you tell us about that night? What it looked like? How big was it? Stuff like that.
Like I said, I don't remember. I just know it wasn't no kitchen knife.
I think you just told me, but I'm not 100% sure I understood it. So where did he get it? Was it on a table?
I don't recall where he picked it up from. I just know he picked it up and charged at me with the knife.
Okay.
I don't remember where he got it from.
Okay.
Just know, yeah.
He charged at you with it.
Yes, sir.
Can you show us with your hand how he was holding it?
I just remember he was like this, not like running with it, just like this, like holding it, like trying to come, trying to come towards me. Yes, sir.
Okay. What was he doing with that hand that was holding the knife?
I don't remember. I just remember him coming toward me with the knife. I don't remember what the whole.
Okay.
How he looked.
Was he running? Was he slow walking?
He wasn't running. He wasn't walking. He was just trying to come towards me. People was pulling him back to not come towards me.
So other folks were holding him back.
Yeah, to not come towards me, to stop him.
All right. Was he also talking while he was doing that?
I don't know. He was just mad.
Okay. But he was mad. You could tell he was mad.
Yes, sir.
You said, I'm trying to get this right, a minute ago, you lunged back. So you went back.
Yeah, I stepped back.
Yep. Okay. You did that because you didn't want to get stabbed.
Correct. Yes, sir.
And the only reason you didn't get stabbed is because other people grabbed him, right?
He wasn't gonna stab me.
No, you lunged back because you were concerned he might, right?
Yeah, I lunged back, but he wasn't gonna stab me.
But he didn't stab you on this particular, didn't, right? In part because people grabbed
Coming
him.
back. Yes, sir. Mm-hmm.
Now, all this stuff we're talking about right now, everything we just talked about with Maurice, the knife, and all that, when the police first questioned you, you didn't say any of that. Right?
I mean, I said something, but I didn't say about the situation. I didn't say about the murders.
Well, what you actually said was, I don't know what you're talking about. I wasn't there. Does that ring a bell?
Yeah, that's what I said.
Okay. So all these things you're saying here to this jury, the first time you were asked about them, you said, I don't know. I can't help you. I wasn't there.
Yes.
You said, why are you holding me? I didn't do nothing. Right?
Mm-hmm.
In fact, you said that over and over and over.
Mm-hmm.
That wasn't true. Right?
First statement. Of me saying, of me denying.
All those things, right? Those were all lies. Right?
It wasn't true. The first statement. It wasn't true.
But you swore it was true. You said it's true. It's true. Let me go. I didn't do anything. Right?
Yes, sir.
But you were lying.
Yes, sir.
Now, your testimony to this jury makes it sound like you didn't do anything wrong. Like, you were there, you were watching, but you didn't really participate. Because that's what you eventually convinced the police, right? There, but you didn't participate.
Wanna come up?
Okay, sounds like we've got another sidebar.
This is the sort of thing this is the sort of thing I'm asking about. You were talking about people being violated, right? That's the term you use.
Yes, sir.
I think you're using that term kind of to mean punished. Is that right?
Yes, sir.
Okay. Before that happened, was there a vote?
Yes, sir. It was. And that I remember. It was.
When you just testified to this jury, when the prosecutor was asking you what happened, that didn't come up.
No, sir, it didn't.
And now you're telling this jury that in fact there was a vote?
Yes, sir. It was.
You were one of the people voting, right?
Nah, we didn't vote. He asked us. We said no. We didn't agree to it.
So your testimony under oath is that you said no.
Yes, sir.
What about your cousin? And why?
He said no as well.
What about the other folks who were there?
We didn't know them, so I don't really recall them even saying anything. I don't know if they said yeah or no. I don't remember that. I don't.
You know, your testimony is that you don't remember.
They could agree with it. They could not. I don't know. I don't know. I don't remember.
This is a vote that, according to you now, resulted in 2 deaths, right?
Yes, sir.
And you're telling us you don't remember the details?
7 years ago, man. I don't remember who actually said, let's do it, let's not do it. I don't know. It was 7 years ago.
But you want this jury to believe that you, in this vote, voted no.
Yeah. You said no.
It wasn't long after that before you were holding a knife, right?
I was past the knife.
You were holding a knife.
Yeah, I was past the knife. Yeah.
And you want it to be passed because you think that sounds better.
No, sir.
Because I'm not asking you how it ended up in your hand. I'm asking you what was the knife.
Yes, sir. The knife was in my hand.
Was it the same knife that you've been threatened with?
Been threatened with?
Yes. By Maurice minutes earlier. It was the same knife that ended up in your hand.
Yes, sir. It was the same knife.
You took that same knife, according to your testimony, and you stuck that knife, you stabbed with that knife into Maurice. Yes?
No. No.
You told us under oath minutes ago that you did.
Larry. He made me stab Larry, not Maurice.
So your testimony is that you did not stab both?
No, sir, I didn't.
So that knife that you've been threatened with, you only stabbed one of your friends?
Yes, sir.
3 times?
I don't remember. Once or twice, as I told her.
These details matter to you, right?
Yes, sir.
They're important, right?
Yes, sir.
And you want to make sure that the jury and this court don't know what really happened to Maurice and Larry. Isn't that true?
No, that's not true.
Well, when you spoke to the police, you felt very strongly you did not want them to know what happened, right?
Yes, sir.
As you told us earlier today, because you didn't want to get caught. Was the first thing I asked you. And you talked, I know you may have talked with multiple people. One of those people you talked to is in the courtroom, right?
Yes, sir.
Can you point at the officer in the courtroom who spoke to you? Do you know his name?
Detective Tonelli?
That's correct. Do you remember if Detective Tonelli was there every time that police were speaking to you?
Yes, sir.
He was.
Yes, sir.
Was he running the room?
I don't remember. I just know he was there. He was present.
Okay. He talked to you a lot, right? These weren't short conversations, right? And that's not a trick question. I mean, it's not like you didn't talk to each other for 5 minutes or something. You talked to each other for hours, right? Okay. One of these meetings is 126 pages, just one of them. Does that surprise you? That even just one of them is 126 pages long?
No, don't surprise me.
Okay. And the police told you that you were going to get charged with murder, right?
Yes, sir.
Now, you didn't want to get charged with murder, right?
No, sir. I didn't.
So you lied to this man right here, right? Yes.
Yes, sir.
And you didn't lie once or twice or 3 times. You lied over and over and over, right? Yes.
No. Just that day I got picked up. Yeah, I lied. The day I got picked up. Yeah, I lied. I'm gonna get charged.
And you were hoping that if he believed your lies, they'd just let you go, right? That was your hope.
Yeah, but we weren't. I knew I wasn't going nowhere.
But that was your hope, right?
Yes, sir.
He told you he wanted to help you. Remember that? He said it over and over.
I don't remember the conversation. I just remember him speaking to me. I don't remember the conversation.
He told you that you could get life in prison for murder. Do you remember that?
Like I said, I don't remember what he said. I just remember him speaking to me. I don't remember.
When he was telling you that he wanted to help you, he also told you part of your job would be to help yourself. Remember that?
No, I don't remember the conversation. I remember me speaking with him. I don't remember the conversation, everything, all the details that was spoken in the interview. I don't remember.
Well, he told you details about his own life, and I'm not going to ask about that. But remember him? They got your food, right? Something to drink. Yes.
Yeah.
Okay. And you sat together. He wasn't yelling at you, right? He didn't yell at you. He just told you needed to help yourself. He wanted you to give him details of what had happened in both of those All three of the murders.
Yes, sir.
And he told you that you need to take care of you. Do you have a relative who ended up getting a lot of time on a robbery? You remember telling him about that? I mean, I said a lot of time.
Robbery? Not that I recall. No, sir, I don't remember that.
Remember him telling you some stories about different things that have happened to him when he's a police officer?
No, sir, I don't remember the situation. I don't remember him, the details in the interview. I just remember speaking with him. I don't remember.
At the end of the first interview, do you remember him getting a little bit frustrated? I don't mean yelling at you, a little bit frustrated that you weren't answering the questions the way you wanted. Remember that?
No, sir, I don't.
Remember him cleaning up his papers and saying, it's gonna be your last chance.
That part I do remember.
Okay. But it turned out it wasn't your last chance, right? Because he came back, right? Came and talked to you again. Right?
He could have. I don't know if he came back or not.
You remember that there was more than one time you met with the police, though, right?
Yes, sir.
Okay. When he was telling you things like that he could help you, that this is your last chance, you still didn't want to answer his questions.
No, sir, I didn't.
And you, in fact, didn't answer his questions truthfully, right?
No, sir, I didn't.
Okay. But at a later time, you changed your mind.
Yes, sir.
You decided to start telling him some of the details about the murders.
Yes, sir.
Because you, in fact, got charged with 1, 2, 3 murders, right?
Yes, sir.
You didn't want to start answering his questions, but you decided that it was the best way to get out of trouble.
You could say that, but it was just the right thing to do at that time.
It wasn't the right thing to do when you were first talking to the police, right?
It's too scared to do it, man.
And you were so scared in this whole situation that you took Maurice's shoes.
Wasn't me. I don't recall that.
We've already talked about how those shoes, the Timberlands, were recovered at your girlfriend's cousin's house.
They was my Timbs. All black Timberlands. That was mine.
That you took off the body of your friend.
No, sir. I don't recall that.
I'm holding in my hand the plea agreement that you signed and executed, okay?
Yes, sir.
I'm giving this to you. I'm gonna ask you some questions about it, okay?
Mm-hmm.
All right. First, recognize that signature.
Yes, sir, it's me.
All right. Yeah, and that signature is on the plea agreement itself. About this signature right here.
Yes, sir, that's me.
Right. And that is on your motion to enter a guilty plea. Now, looking at this, looking at those charges, How many murder charges were you looking at? Right there.
I was looking at three. 3 counts of complicity to the murder.
And a fourth count, what's that fourth count?
Tampering with physical evidence.
Do you remember what your plea is on this?
10 years, I believe 10 years, 20 if probated. Sorry, my sentence out.
Well, first, all 3 of those murder charges were reduced, right?
Yes, sir.
As part of this plea agreement, they were reduced from murder to what's called facilitation to murder, right?
Yes, sir.
And instead of looking at a life sentence on count 1 of murder, what were you looking at on just that count? Do you remember?
What account? Keep referring to it. The one murder charge?
The first murder count.
It's no murder's 25 to life.
And because of your plea agreement, that charge got reduced to facilitation. And then what we look at instead of life in prison. I can bring this back to you.
When it got reduced, I was looking at 1 to 5 for each count.
Correct. Instead of looking at life, you were now looking at 5 years, right?
For each count.
On the first count. On the second count, same thing, right?
Yes, sir.
And on the third murder, same thing. On the tampering with physical evidence, same thing.
Yes, sir.
It says on this recommendation, the Commonwealth recommends a sentence of 5 years on each count. 3 counts of facilitation of murder, 1 count of tampering with physical evidence. The Commonwealth recommends a total sentence of 10 years if to serve, or 20 years if probated.
Yes, sir.
When you decided to enter that plea, to cut the deal, that was your understanding of the deal, right?
Yes, sir.
Instead of looking at life, you now would be looking at either 10 years in prison or 20 years over your head if you got probated.
Yes, sir.
It says further that the Commonwealth, that's the prosecution, objects to probation. Right?
Yes, sir.
But it had another condition in there. It says the defendant agrees to testify truthfully in any and all proceedings of these events.
Yes, sir.
That was a condition.
Yes, sir.
And that's why you're here today.
Mm-hmm.
And it says, should the defendant fail to testify truthfully as determined by the court,
Yes, sir.
then the Commonwealth reserves the right to withdraw from the plea and proceed against him, you, with the original charges.
Yes, sir.
Do you understand what that means?
Yes, sir.
That the Commonwealth, at the end of your testimony, could ask the court for a hearing and argue that you haven't been truthful, argue that they're not satisfied. Does that make sense?
Yes, sir.
And if they won that hearing, then you'd be looking at life in prison again.
Yes, sir.
And you don't want that to happen, do you?
I've been in prison. I don't want to go back. Of course, I don't want to go to prison.
You, in fact, served about 6 years on this. Is that right?
Roughly 6 years, almost 6 years. Yes, sir.
You got out on the 1st of September, 2021. Does that sound right?
Yes, sir.
You weren't happy to answer any questions from the police officer truthfully, right?
I didn't answer truthfully. No, sir.
But in order to keep from a life sentence, you did, right?
Yes, sir.
You didn't want to come here today and testify, right?
No, sir.
But in order to keep this plea agreement intact, you did.
Yes, sir.
Thank you. I don't have any further questions. Judge, we would move to introduce defense exhibit number 2.
All right, so admitted and Brice Rhodes.
Mr. Taylor, jumping back to the beginning of the defense cross, he asked about the gun from the Christopher Jones murder. What happened to that gun?
I know he wouldn't got rid of the gun. I wanted it back because, of course, it was my gun from begin with, for my protection. I wanted the gun back. He wouldn't give it to me, so he did whatever he did with the gun.
And when you say he, to whom are you referring?
Brice.
And by Brice, do you mean the defendant in the courtroom?
Yes, ma'am.
The conversation that occurred, it was characterized as a vote. Walk us through that, because what do you mean? What happened in that conversation?
When he said something about the vote, I do remember it was a sort of debate on what should happen. And I just remember we didn't really agree to it. We didn't want to do it.
Like, was this a vote where you all wrote down yes or no on a piece of paper and he added them up?
No, we just talking. We just speaking to us about it happening.
Where did this occur?
In the living room, and wherever inside the apartment. I don't know, somewhere in the living room, hallway. I don't really remember.
At that point, was Maurice tied up?
I don't really remember at that point. I just remember it was a vote. We didn't agree to it.
Was it within earshot of Maurice? Like, do you think he could hear you all talking about it?
Possibly. We was out. It's not a big apartment, so, and it was five of us or 6 of us in that night, so it wasn't, we could hear.
Do you remember where in the time frame that occurred?
No, ma'am.
Was it before he got stabbed?
Could have been. Yeah, before. Yes, ma'am. It was before. Had a debate.
Do you remember, I know you said the knife was not a kitchen knife. What do you mean like, how would you describe a kitchen knife?
Kitchen knife that, you just cut things on, like cut something with, like, but this is a personal knife.
Okay.
A personal knife that you carry around with you.
Would you have it in your pocket or?
A pocket knife, yes, ma'am.
How old are you now?
I'm 25.
And how old were you in 2016?
17, ready to be 18.
What was your birthday?
June 20th.
So did you turn 18 when the prosecution first started on this case?
Yes, ma'am.
So at that time, did you move from a juvenile holding facility to adult jail?
Yes, ma'am.
When you were talking to Detective Tonelli on May 25th, 2016, at age 17, did you have any family you could ask for advice?
I'm sorry, repeat the question again.
Did you have any family you could ask for advice?
About the situation?
Yeah.
I didn't have no family to really go to. I was out here,
Between the 22nd and the 25th, did you talk to anybody about this case? Like between when it happened and when you got picked up by police?
I don't really remember. I might have, but I don't really remember who I talked to.
Who would you have talked to?
Anybody was a friend or ex-girlfriend or something like that. I don't really remember.
Friend or girlfriend? Did you said your father had been killed?
Yes, ma'am.
Did you go to your mom and ask her for advice?
Our relationship was kind of rocky at the time, so Probably not.
Did you have any older siblings?
I'm the oldest on both sides.
So that night, you talked to Detective Tonelli for, I believe it was 126 pages. I've got that correct. I mean, it was several hours, correct?
Yes, ma'am.
And you told him to summarize that you didn't know what happened.
Yes, ma'am.
And why did you say that?
I'm just scared. I didn't know what to say in the situation.
And just to clear up the thing with the Timberlands, so did you all kind of share clothes? Is that what you're saying?
Yeah, we all did pretty much. Yes, ma'am.
Who had the Timberlands on when that night started?
I believe I did, as I remember.
But they had started out as Maurice's shoes?
We was trading shoes. I used to wear his shoes. He wore my shoes time to time, stuff like that.
Okay.
But I had them on.
Then why did you leave them at Monisha's?
I remember that they had from all the blood and stuff on the crime scene at the scene. My boots had a spot of blood on them, so I put it in Monisha's closet. And they was found there.
After you talked to Detective Tonelli that first time on May 25th.
Yes, ma'am.
At the end of that, were you arrested?
Yes, ma'am.
Okay. And then did court proceedings start?
I was a juvenile. I went to court, and then I turned 18. I came to the jail.
Okay. And did you come to court from time to time?
Yes, ma'am. I did.
At that point, did you get a lawyer?
Public defender.
Okay.
I didn't get a lawyer, personal attorney.
And then in 2017, you gave the second statement, correct?
Yes, ma'am.
And those were the only two times that you sat down and gave a statement to Detective Tonelli?
Yes, ma'am.
Okay. Or any police, right?
Yes, ma'am.
Why did you give the second statement?
Just to come forth, to be honest.
Okay.
I felt.
And that, I mean, also, I mean, I'm not trying to skew what you're saying. You wanted the deal that you got, right?
Yes, ma'am.
I mean, it's better than going down for murder.
Yes, ma'am.
Okay. But did the promise of this great deal cause you to tell a bunch of lies to Detective Tonelli and this jury?
Sorry, say it again.
Did the promise of this deal cause you to tell a bunch of lies to Detective Tonelli at the second statement in 17 or to this jury today?
No, ma'am.
And the plea agreement was that the charges of murder would be amended to facilitation of murder, correct?
Yes, ma'am.
What's your understanding of facilitation?
Yes. So it's my understanding.
Yeah, what does that mean to you?
He was pretty much there. He was there when it happened, but you didn't do nothing about it. You didn't call the police or try to, they say stop the situation. So
Okay.
I see you was there. You facilitated by being there, present when it happened.
Like helping it along to some extent?
Yes, ma'am.
Okay. And is that how you feel about your role in this now?
Yes, ma'am.
I mean, what do you feel?
Right now, I just looking back, we was just kids. We was just young. We didn't really, you know what I'm saying? I know me, I wasn't even thinking about stuff like that. I was too busy worrying about where I was gonna sleep at and being home and stuff like that. I didn't have a mentality. I didn't have a mentality of all that. I was just, I was just present when it happened. We never knew this was going to happen. We never knew. It was talked about, but we didn't believe. At the time, it was partying and stuff. We don't believe this stuff, man.
I don't have any further questions.
Mr. Griffiths?
I don't have any further questions.
Mr. Taylor, you're free to go.
Didn't wish
Counsel, you all would approach.
Okay, so it is basically 4 o'clock. They said it would be a shorter day. Do we have a short witness, or is that the end for the day?
All right, so ladies and gentlemen, we are going to go ahead and break for the evening, but I want to give you a little bit of information. Number one, I'm going to read the whole admonition again, just to be clear. Before you go, please recall the earlier order. You are not to do any research on this case or post information about this case anywhere. If you accidentally encounter information about the case from any source, it is your duty to bring it immediately to the attention of the court. Do not use any internet search engines, websites, blog, or any other electronic tools to conduct any research about this case or to help you deliberate on the case. And do not communicate online or elsewhere with anyone connected to the trial other than here in the courtroom where you hear testimony. Now, tomorrow, I'm going to have you all come in at 9:15, but tomorrow we're not going to have lunch. We're just going to stop at 1, maybe even a little bit before 1. But, you know, we're going into the week before the holidays, and you all have been going long days every day. So I think everyone can really use the half day tomorrow. The other good news is that it looks even more likely than it previously was that this will not go beyond next week. So that is good, and that is in part because we have all been able to be willing to sit here and go through the day and listen diligently, and so that's very much appreciated. And we will see you tomorrow outside the doors at 9:15. Don't forget your phones. Sure. It's okay.
I remember in the first beginning of the
The attorneys want to come up. I just don't want to answer this question without you guys up here.
Oh, I'm sorry.
It's okay. It's fine. I just want them to be.
Okay, well, that concludes it for today. So they said 7:15 tomorrow, so that will be 7:15. No, they said 9:15. That's 7:15 for me. I was thinking, no, I don't want to get up at 5:15 in the morning. Okay. Suddenly 7:15 doesn't sound so early when faced with the alternative. Oh, well, Dave, I lived briefly in Portland when I was a baby.
Some photographing and documenting if there was something of significance to do.
It rolled over. Okay, well, I'm glad for the half day tomorrow because I have a 1 or 2 o'clock appointment tomorrow, so I don't have to worry about running off and leaving people dangling during a break. I'm going to have to go back and listen to his testimony again. My mind tends to wander. If I put it up to 1.25, I think I'll catch a little more. But it looks like it's a beautiful sunny day, and I need to go out and unload the car and put some things in the shed. So I will bid you good day, and hope you'll all come back tomorrow, and we'll have our short day, and we'll see you tomorrow. Have a great afternoon/evening. Bye-bye.